Heyo! I didn't plan to stream this. Oh, Jesus. But today, the prosecution did probably the most evil thing you can do. Sorry. The most evil thing so far in this. And so we're going to go back an hour to the beginning of the live stream because they revealed something for the first time with this new witness. And it is... Hey, welcome to the show. All right, let's see here. At the stage. Oh, not that one. This one. All right. Yeah. This is live from today. I still haven't done the recap of earlier this week. I will do that when I get it. But this is bad. This is so bad. And you need to hear it from the beginning. I will be playing it in crops. No subtitles. Well, we'll have to do.
Our first witness perhaps needs to be brought out. I'll let the court direct us. She is going to be brought out as opposed to walking in from in the back.
Okay.
So the court has us to bring her in after she's called.
How is she dressed?
In the attire provided to her by the state.
Okay. Your choice. If you like, we can bring her out right now and have her sit if she's wearing that, or sir.
Yeah, what she is revealing is that this witness is in prison colors. That is what she was talking about, in prison colors. And you will soon find out why she is in prison colors. I will try to find
sir. Good afternoon, everyone.
Before you say anything, Mr. Steele, did you? No, don't go anywhere. Don't go anywhere. Did you offer her to be dressed in civilian clothing?
No, we just we let her. No.
Was
Yeah. Did the judge even know? Nope. He found out just as the defense did. And as you heard, they didn't even offer her civilian clothes. Now, in my opinion, the one reason to do that is power play. They want this witness there in a prison jumpsuit. Don't know yet, because the next hour they are debating what you will be about to hear here. I found out, watched a bit of it, thought, will this be something normal shenanigans, bad things from the prosecution? No, this is bad.
Is that due to because she didn't want to, or is it because of?
There were circumstances So she's our witness. We're fine. I'll speak louder.
Okay.
Your Honor, no, under the circumstances, we did not. And she is the state's witness, and we do not have a problem with her coming out. There's
Okay.
no problem with that.
I just wanted to ask. Now, Mr. Steele, I'm sorry.
Additionally, Your Honor, we have requested and we wanted to make certain that it is understood that her face is not to be filmed.
And why has she been threatened, or is that to prevent her from receiving additional threats? Because I assume that she's in custody. Is that correct?
That is correct.
Okay. All right, Mr. Steele.
Notice what she implied here. What she's insinuating is that this woman is someone might need protection. The insinuation is that she's scared of the defense. That is completely false, and you will find out why.
Now.
Good afternoon, sir.
Good afternoon, sir.
And good afternoon to everyone again. Mr. Ryan, I'm glad you're okay. I haven't said anything of substance. Your Honor.
Sure.
This is the first I heard about it, so I just want to inquire if we could have a minute with the state. There may be some impeachment information that we're entitled to under Brady with the prongs of impeachment as well as exculpatory. And and I know nothing about it, but if the witness is not going to say anything, I'd like to know that before the jury comes out, or if she's going to invoke some amendment, privilege, I'd like to know that too, because it should not happen in front of a jury. Now, I have no basis. I'm just learning about this, but that's what I would like to find out.
Okay.
Yeah. The state have not told anybody that this specific witness is coming out in prison garments. And of course, seasoned lawyers, something's going on. We don't know what it is. Let's cover some bases.
She failed to appear. She was picked up on a material witness warrant. That is why she is in custody. So
Okay.
there's no all of that going. There are no outstanding charges. She did not appear. She was subpoenaed. She did not show. We had to find her.
I understand, but if there were any communications, I'd like to know. If there were any communications at all, like why didn't she appear? What was said? I mean, if you have that, we're entitled to it.
Yeah. If the state is having a subpoena out, and that witness, for some reason, chooses to not appear, that information should be turned over to the defense. No Kurasan, they arrested her for failure to talk to prosecutor. No. She was subpoenaed to appear in court today. And she didn't show up. So they arrested her, put her in jail, put prison garments on her, and now they want to show her to the jury in prison garments for unknown reasons. And that's the issue here. Unknown. And yeah, if this witness doesn't want to show up, there's a subpoena, yes, you can arrest her. But keeping it secret, we don't know how long she's been in custody. Maybe she was subpoenaed for interview preparation, whatever's. We don't know. We know nothing. And why do we not know anything? Why don't the defense know anything? Because the prosecution chose to not tell anyone.
No. You can certainly, for the benefit of all counsel.
Okay, thank you, Em. It was actually yesterday, Nick. She's been there overnight. Yeah. Thank you, Em. And if she was subpoenaed to today, why was she arrested yesterday? Well, the prosecution wanted to be sure that she showed up. They have a pre-testimony interview of sorts. Well, she just said there was no charges. How can I treat her like a prisoner? Because this Ms. Love is a vindictive bitch. If you don't do exactly what she says, she becomes vindictive. You could probably do 1,000 different things to make sure a witness shows up for testimony. This is how Ms. Love shows it.
Indicate any conversations that you may have had with a witness prior, which caused you to, that would be, I guess, responsive to Mr. Steele's inquiry.
Okay. Your Honor, the witness has indicated from the beginning that she did not want to testify. When I met with her late last year with Chief Investigator Randolph with our office, we spoke, and she emphatically indicated she did not want to be involved. We told her that we had to, this is what we have to do. She indicated that Mr. Anderson, who is her child's father, was the way that she said initially, she started off with, I blocked everything out from then. I blocked everything out. And I said,
recognize that. Blocked everything out from back then. Sounds like we have a Mr. Bean issue. And the prosecution, front size, doesn't she have the right to an attorney? She should. If they arrest her under a subpoena, she should have representation. She doesn't. And the insinuation here is that she hasn't even been offered. But don't know if she asked for one. We simply don't know.
Okay, let me just start off with the fact that I'm sorry that all of this has happened to you. And then she said, I've been in a bad place. I went to prison. I learned my mother was sick, terminally ill while I was in prison. The year after I was released from prison, my mother died the day after my birthday. And there have been times when I didn't want to go on, but I have these 3 boys, so I have to go on. We talked about herself, her family. She indicated that when I spoke with her and said, let me just say, I asked her whether anyone ever contacted her after following the 2013 robbery by the defendant Williams and Mr. Murphy. She said no one had ever spoken with her, that we were the first ones that spoke with her about that. I said to her, well, I suppose, and I was remembering differently than what the report read. I said, I suppose that's because the officer said that they called you and apologized and gave you your stuff back. She said, what officer said that? When did they give me my stuff back? I said, this is what I think I remember from the report. We had it seemed amicable kind of interaction. She agreed to meet with us again as time went on, if we needed to, when we needed to. Later, as it grew closer to the time that she needed to appear in court, she came here for court. Earlier this year, I went outside to talk with her again. I had reached out to her by various means between that time and the time I first met with her. When I sat down to talk with her, she said, I want to take my life, essentially. And I asked her, what had happened? Why? She said, you're making me feel that way. So
As a prosecutor, as a lawyer, when you have somebody threatening to end themselves because of you, you have some ethical responsibilities to make sure that person gets some kind of psych evaluation. guess what this cunt didn't do? Not once. She never told the prosecution. Oh no, she didn't tell the defense, the judge. She might have told the other garbage in her office, but she didn't make sure this witness got mental help. Why? I assume she wants her that way on the stand.
I walked away from her and called in an advocate. An advocate and our lieutenants, our investigators were called. They then called an ambulance. She indicated that she did not need an ambulance. We
calling an ambulance? No. Ambulance for what? If she has a mental breakdown, what ambulance? What kind of fucking ambulance? You have an ethical obligation. The second you hear that out of her mouth, you can keep her where you are interviewing her, and you get a psych evaluation there. You're with a witness who you are being unethical to. And what? No, not an ambulance. You get a psych evaluator to your location. Getting an ambulance is jack shit because ambulances cost money. But if you bring a psych evaluator to you, the witness doesn't have to pay. JC, she wants the juror to have the narrative that they are afraid to testify due to defense when it really is the state. Yes. And remember, this case that they are talking about is somewhere around 2011, 2013, where this witness was supposedly a victim. They had talked about this case for a bit. They could easily have stipulated. They could have easily drawn up an affidavit, easily using other kinds of evidence to get the story out. No, ADA Love does a power move because she can. She doesn't need to, but she can. Here's the thing. When she also doesn't reveal all of this to the defense, issues arise. And in a normal court, a judge would have got the ruler out and said, ADA Love, come up to the bench, show your hands, and then whack the living frick. But you know, this isn't a normal court.
After meeting her the next time, most recently, we were trying to reach her to appear on March the 26th. We reached out to her several times. She did not appear on March the 26th. One of our lieutenants reached out and said, we don't want to have to get a material witness warrant for you, but you have to answer our calls. We then came to, we secured a material witness warrant. In the meantime, after that had been secured, she texted our office and said that she was in a hospital, but we had eyes on her home. Her car didn't leave the driveway. So officers went into her home, went to her home and executed a material witness warrant for her arrest on yesterday. She was taken into custody yesterday. She was not happy. And
another thing that could have been done, you could have sent the cops over to tell her, you need to be in court tomorrow at this time voluntarily. But we will make sure that if you're not there by noon, we will get you. And then you can, if you want, have some kind of officer follow her around just to make sure. There are hundreds of different ways. One of them does have a requirement. Most of these have a requirement. Don't be a cunt to the witnesses. Because if you are, they might not want to be accommodating towards you.
As a result of that, Your Honor, I also wanted to bring to the court's attention, as far as what she will say when she comes in here, there's no privilege to be invoked. So I know she does not want to be in jail. She has made.
So what you preemptively did was to hold her in contempt, which is the judge's job. And the judge seems equally surprised, but something tells me he will get over that soon. And yeah.
I'll call them savory comments as to what can be done to her. She's not a fan of our office, and that's what we are. Additionally, Your Honor, as a result of all of those facts, I wanted to just point out, I don't know if she's going to be cooperative. I don't know if she's going to be hostile, but.
Well, you made sure that the odds of her being hostile is quite high, didn't you, ADA Love?
I've printed out for the court's consideration and copies for counsel of questions. I may have to ask her questions that are closed-ended. They will be maybe one-word answers or closed-ended questions. Those have tended to garner objections, but I just have case law that says a question that requires a yes or no answer is not a leading question. A leading question is a question not suggesting the desired answer. Is not leading where it inquires only into a single fact. That's Milner, Milner versus the state.
And just to make sure, tomorrow is Good Friday. It's a holiday in Sweden. I don't have to work. So if you want to, I can bring out the Wheel of Regrets today. $50 a spin. Just saying.
58, Georgia app 425. Wiggins versus the state 338, Georgia app 273 is a 2016 case. The Wiggins is 338, Georgia app 273, which states a question is not open to the objection that it is leading when it does not suggest the answer desired. So the court found that questions such as, now, would she actually hold your hand during this time? And now, did he ever get his private part inside your vagina? That they did not suggest the answer desired. That the questions, in fact, did inquire into only a single fact, but because they did not suggest the answer desired, the questions were not leading. The court also cited cases wherein the question, was any money demanded of you, was argued as leading by an appellate. The court said that was not a leading question. And allowing a prosecutor to ask a 14-year-old witness, did you see the defendant with a gun, was also not a leading question. And as to that issue, the last case that the state has for the court's consideration is Burden, that's Burden versus the state, 332 Georgia app at 811. That's a 2015 case, which also says a question is not open to the objection that it is leading when it does not suggest the answer, but only inquires into a single fact. They cited Milner for that assertion on the court's part. So, Your Honor, I do anticipate asking closed-ended questions as opposed to more open-ended questions. But unless the witness proves herself hostile, we won't need to lead. If, however, she does prove herself hostile.
Luke Pearson, by the way, would you be down to drinking stream with Sean for Richard Allen? He's about 6K from his goal now. My plan is, because the trial will start May 10th, I think, if we get there, or something of that sort, which coincidentally I already planned my birthday stream on. So yeah, there will be, in some shape or form. Fun size, why are the sex questions relevant? That is her explaining to the judge that there are statutes about how certain type of questions can be regarded as not leading. So she's trying to preemptive strike out any objections from the defense. So in my opinion, she had all of this planned out the moment she realized, oh, this is a hostile witness, or this is a witness who really don't want to come here. And instead of trying to be a good person, explaining why she's needed to be a witness, that the court can assure her that she can be spoken to with her initials, that her face won't be shown, and all of that stuff to ensure her safety. She decided to be a cunt. I think, speculatively, of course, for legal reasons, that she has planned this witness being in prison garments on the stand for weeks. That's my speculation.
The state is prepared to ask the court for permission to treat her as such. And we have the cases for that as well. And I would point the court's attention to ISA, spelled ISSA, versus the state,
What was that, sorry?
2017.
There's some more recent cases. I thought Brown versus the state, 314 Georgia 193.
We have that as well. Thank you.
All right.
So we are not at this point asking that she be treated as
We
a
need to see
hostile.
what she says. And
Right.
What comes up.
ISA, Your Honor, is,
That was Mr. Matthews.
I know, I was just addressing the
Okay,
court, but
that's
well,
okay.
it's gonna fit. That was 340 Georgia app 327 at Penn site 340.
All right. Thank you, madam.
You're welcome, Your Honor.
Yes, Mr. Steele. I'm sorry, Mr. Harvey.
Let me just comment for the record that we had a 1 o'clock start today. None of it was provided to us this morning or yesterday. So, I mean, it's pretty disingenuous to come in and start, hey, I'm speaking, to start citing cases and saying I can ask these questions after the state arrested somebody yesterday and holds them in jail, number one. Number two, everything that I heard that was stated to the state is Brady material. The person's mental state, what she said, the statement that was given, none of which we were given that I know of. So and number three, I do object to the public not being able to see this witness under the authorities that we have already provided to the court and argued previously. So number one, I don't think this witness should be shielded from the public. We have been provided with nothing to verify that she is in any particular danger that would overcome the Sixth Amendment openness provision of this particular trial. Number two, I would like that Brady material and a chance to digest that with my co-counsel prior to this witness testifying. So I object on all of those bases.
Your Honor, if I may respond.
Yeah, you all need to hit the like button.
Not showing her face on camera is a violation of their Sixth Amendment rights. This court has made these proceedings open to the public. The court streams these proceedings via Zoom down to another courtroom in this courthouse for anyone who chooses to see it. Anyone who desires to do so can come inside the courtroom by permission of the court, if the court allows, and can go into that other room. What the defendants do not have is the right to dictate where media, who is filming for the rest of the world, places its camera. The camera has been focused on defendants at various times, solely focused on defendants at various times during these proceedings. They have absolutely no right to dictate.
Miss Love, the court has made it perfectly clear to you, to the defense, to anyone, that if a witness wants to be not shown, have their name as initials. So you pretending to be offended by this? This is planned. She has planned all this out. Everything about it. She knew about the reaction from the witness. She planned for it, in my opinion. She anticipated the objections, and now she plays offended. This is evil. Pure evil.
Where the camera is pointed, and certainly not to tell this court what to allow or not to allow to be filmed in this courtroom. Also, Your Honor, on February the 6th, 2024, Mr. Uhelsky provided to this honorable court and co-counsel as well as the media proposed orders on the state's limitation for recording, and indicated in that email that entry of the proposed order would not implicate, let alone infringe, any defendant's Sixth Amendment right. No constitutional provision guarantees a right to televised trials. The public trial guarantee of the Sixth Amendment.
See how prepared she is? She had everything ready for this, and whining again about people actually seeing this. We know the jury doesn't see this part, but we do, and we judge. I do, at least. This is an evil prosecution. I mean, everything you've seen so far is planned out. And as I said earlier, in a normal court with a fair and unbiased judge, she would have been spanked out of court. But I guess somehow this will be the defense fault.
Which reflects a concept fundamental to the administration of justice in this country, certainly does not require that television even be admitted into the courtroom. A public trial implies only that the court must be open to those who wish to come, sit in the available seats, conduct themselves with decorum, and observe the trial process. It does not give anyone a concomitant right to photograph, record, broadcast, or otherwise transmit the trial proceedings to those members of the public not present. That is Estes versus Texas, 381 U.S. 532 at Pennsite 588 through 589.
See, she has
So
everything planned out, all the statutes, all of it. This is so pre-planned. Everything about this is so pre-planned. And I include making sure this witness was terrified enough that she tried to avoid the subpoena. So this manipulation from the prosecutor, the planning, this must have taken weeks, months.
Honor, one, as it relates to an asserted Sixth Amendment right to have any witness have their face broadcast all over the world. There is no such right. And number two, I disagree wholeheartedly with Mr. Harvey. We have provided this witness's name, information. Mr. Harvey has not made any indication whether he sought to speak with her. These statements that she made to me.
Here she goes, blaming the defense. Here's the thing. What the defense is objecting to is what recently happened. They have had access to this witness for a while. I hope, at least months. But I don't think they had access to this. The witness threatening to self-end herself. The witness saying that the prosecution is stalking and harassing her. This was never provided to the defense. But she still tries to make it the defense fault. Oh, they had all the opportunity, all the this, all the... Here's the thing. You can interview a witness, but you don't have to. You can rely on the paperwork, prior statements, some recordings provided from the state. You can, in my humble opinion, you can. But I've heard this jackass judge before arguing towards the defense. Well, you had time. No, they didn't, because they don't know. In this case, they didn't know she was arrested. They didn't know. And probably by now, they understand this has been weeks of planning from the prosecution to make this situation happen. Yeah, she started talking to her a year ago. So maybe this was not maybe not planned this way, but for a year. But you don't get here without planning.
Are very much more inculpatory rather than exculpatory. Brady is exculpatory. She never once even suggested that the defendants on trial, specifically Jeffrey Williams, did not come to her house with Walter Murphy and his brother, while the defendant Williams' brother put a gun to her head. She said that I asked her whether or not the defendant Williams and her child's father, before this point in time, whether they were actually friends, whether they had been hanging out. She said yes. But she said, you know, she did not want to be involved in this. She is just like every other witness. There is no recording that we have received from this witness that we are obligated to turn over. The fact that we are having her brought out in handcuffs, that I'm announcing to the court after her arrest yesterday, as well as counsel for the defendants, that this is the case, and just goes against, flies in the face of the assertion that there's something being withheld from the defendants.
All right. Anything else, Mr. Harvey, before I allow some of your other colleagues to?
Yes, I think the court has been provided with a number of authorities that defendants have a Sixth Amendment right to an open in public trial. That's not even debatable at this particular point in our jurisdiction.
Well, our cameras are in the courtroom at this point in time. The question is safety of the witness and the like.
Nothing, not a thing.
Well, I disagree with Mr. Harvey, so I'm going to overrule your objection. Do you have anything else, sir?
All right, well, for the record, I have not heard one factual basis, not a scintilla of evidence or a proffer that this person has been threatened or is in danger of in any way that would overcome Mr. Nichols and all these gentlemen's Sixth Amendment rights.
Okay, sir. Thank you. Anything else?
Two, impeachment evidence is Brady. Someone who says, I don't remember something now, that's impeachment. A person who—
Did you seek to interview the witness? You had the witness's availability for almost 3 months. So
You fucktard. You fucktard. The prosecution makes a surprise on the defense and you blame the defense. Well, you had access to her. This is so infuriating with this jackass clown judge blaming the defense over this. Well, you had time. You could have interviewed her. Could have. Doesn't have to. Everything this judge can hold against the defense, he holds against the defense. A proper judge, in my opinion, when hearing about this, would have told the prosecution, okay, we're going to talk about this. Sit down, shut up, only speak when spoken to. Siobhan says, isn't that two different things? The judge is saying, yeah. The judge is now arguing for the prosecution again that, well, you had access to her. You could have found this out, that she felt this way, that she da. Yeah, but you actually, remember, as a defense lawyer, you could sit down and ask 0 questions, have a 30-second opening statement, and then play everything on via cross-examination of witnesses. You don't even have to call your own witnesses. You can play by ear during the testimony. But if this is handed to you, that the defendants have rights, this clown is denying them.
You could have gone and interviewed the witness and gotten this particular evidence yourself.
That has nothing to do with whether the state has an obligation, a constitutional obligation to provide everybody with exculpatory, impeachment, or giglio material under the United States Constitution, under the Constitution of the state of Georgia. And the fact that they interviewed them, this person, and that material is useful for impeachment, that is and falls under Brady. And so we're entitled to it. And we're entitled to
Tamekabi question, why is he able to do this to the defense? It's his courtroom. Under the judge's discretion, can they stop this without waiting on an appeal? No, sadly they can't. Sadly they can't. This is infuriating. This judge is supposed to be the neutral part that interprets the law. Instead, he's arguing against the defense more or less as a part of the prosecution's team.
do it before the 1 o'clock when the witness is about to get on the stand in a jail uniform, which is the fault of the state, not us.
I don't think so, Mr. Harvey. That the way had the witness decided to just honor the subpoena, then a material witness warrant wouldn't be necessary. So that's a choice of the witness. Let her finish and then we'll go ahead.
Your Honor, additionally, when she was taken into custody, as I told the court, the witness, when I spoke to her, told us that I made her want to end herself. She accused us of harassing her, of harassing her. So there's that.
Anthony, just briefly.
Yes, absolutely.
I just want to point out to the court, the order entered by this court related to the videoing of witnesses. The order that was entered by the court.
She's going to be videoed. She just won't be shown. They just asked that their face not be shown.
The order that Mr. Uhelski prepared and the court signed says that the witness or state may request that only audio of their testimony be recorded. In addition, for any specific alleged victims for whom there are legitimate security concerns that can be substantiated by the victim or the state, the victim or state may request limited identifying.
Yeah.
Limited identifying.
Yeah. There's the remedy, which all knows about, but the prosecution had a Mr. Bean moment and completely forgot about it.
Of the witness. So I'm not sure that there have been.
Which the prosecution could have told her, you don't have to be scared. We will only audio recording and only named by initials. There's a strong possibility under the judge's discretion that this witness could have been through Zoom with her representation. There's so many ways this could have gone smooth. But the prosecution woke up and shows violence.
Substantiated by the state.
Ms.
Your Honor, I will point out
Hello.
that this witness is now in custody at the Fulton County Jail. We have endured weeks of testimony from a witness whose face was shown, who provided outbursts during court as a result of what happened when it was made public that he was coming in to testify, even when he chose to recall nothing. So we are, based on what has happened in this trial so far, in the interest of justice and in the interest of judicial economy, we are asking that for the sake of this witness, her well-being, her feelings of safety, that we not show her face.
You caused this, you cunt.
Security concerns that are particular to this witness.
Okay, all right, thank you, Mr. Weinstein. Yes, Mr. Mr.
I would ask the court to require the state to proffer in specifics in terms of this particular witness.
I think that already based on what Ms. Love said already, and the court's viewing of what has gone on with the last several witnesses that have had their faces broadcast to the world, that there's a legitimate safety concern. So I'm going to overrule your objection. It's noted for the record.
And for the record, Your Honor, on that same note, the prior witness that came into court stated that his information had been broadcast. I didn't specifically.
He lost his job. He has been harassed.
Yeah. So why didn't you, judge, make that ruling yourself? Don't say his name out loud in court. Don't show his face.
That's a security concern. Do you want you may want your phone number handed out because it's business to you, but for some people, he lost a job.
Losing your job is not a security concern, Your Honor. That's an employment concern.
Well, I disagree. Given everything that this witness told us on the last witness who testified, the court will disagree with your analysis.
And I think that's a slippery slope, Your Honor, because now any witness, based upon the last witness, can come into court and say.
No, that's not true, Mr. Matthews. It's based upon what the witness endures on the stand and the collateral consequences to that. So I'm going to disagree with you respectively. All right, Mr. Sharp.
Yes, Your Honor. So I agree with Mr. Harvey that Brady includes not only exculpatory material, but also impeachment. But in the state's recitation of what occurred in their communications with Ms. Bennett, I heard several exculpatory statements or things that I deem exculpatory, that she has not been harassed or threatened by any individuals here, that she told the state that her significant other continued to associate with Mr. Jeffrey Williams after she made these accusations. That she is.
I don't think that was said by the state or by
that
the
she
witness.
accused the state of harassing her.
Yeah, okay, that was.
And so these are exculpatory statements. These are impeachment. They fall under Brady. And Your Honor, I would ask, and I have something else after this, but I would ask that the state, I noticed Ms. Love said we don't have any recordings that we are obligated to hand over, which.
Yeah. That she proffered that answer. We don't have any recordings we want to hand over, which means they have recordings.
Qualified her statement about recordings. I would ask that any recordings, any communications, any emails, any written statements by detectives, any notes that involve these episodes with Miss Bennett and oral statements be reduced to writing that have anything to do with Miss Bennett, because we are obligated to impeachment and exculpatory information. Additionally, Your Honor, I would ask that Your Honor, instead of calling the jury out to have the initial determination of where Miss Bennett is and if she's a hostile witness or not, that we have a hearing outside the presence of the jury. I would ask that Miss Bennett be provided legal counsel, because it appears that she may be under some legal jeopardy. She may have given false statements back then, and she's being brought in to testify now. And I would ask that she be provided legal counsel. She'd be allowed to communicate with legal counsel. And then we have a hearing outside of the presence of the jury to make some determinations before the jury hears from Ms. Bennett. Because I think there's a high chance of we're walking on thin ice with unknowns here. And of course, we're finding out about this for the first time.
Did you interview her as well?
For fuck's sake, Judge. This has nothing to do with them interviewing her for their case. The state, when doing interviews, recordings, with these statements, they arresting her, keeping her, that is something they must hand over. And they didn't. It has nothing to do whether the defense interviewed her or not. But this judge is now making it the defense fault. He blames the defense for the misconduct of the prosecution again.
Seek to interview her?
I seek everyone,
Did you seek to interview her, Mr. Sharp? Yes or no?
Your Honor, I know.
Did you seek to interview her? Yes, you personally, on behalf of your client.
Me personally, I have not.
Okay,
She has been interviewed.
all right,
So
okay. Anything else?
I don't do everything involved with my cases. There's investigators, there's other attorneys.
Okay, did you have an investigator go and find?
That is attorney-client privileged information. You're fucktard. You're absolute fucktard, Judge. You are asking the defense for attorney-client privileged information. You piece of garbage.
Did
Did
Fucktard.
you
me
find her?
personally? No, I didn't.
Okay, all right. Have a seat. Anything else? Anything else?
No, that's it.
Okay, all right. Mr. Steele?
Thank you, Your Honor. I just would like you to consider this as well. So when I researched, I heard the former witness, Mr. Bean, his answer was consistently, I don't recall, something that I don't remember, I don't recall.
Among other things.
That's pretty much, my memory was, I don't remember.
Okay, among other, yeah, I would concur that was a lot of what he said.
So I researched that to determine whether this is I understand hearsay, if a person doesn't recall, then you lay a foundation and you get in the prior inconsistent statement because, you know, whatever they said or prior statement. But under confrontation clause, it seemed to me, there's not all that much on it that I could find, but that the federal courts and Georgia, one case in Georgia, has said that I don't recall, the person's not shutting down, so that satisfies the confrontation clause, but constitutional. So statutory is protected because I don't recall lots of cases say you can impeach with a prior statement once you lay the foundation, and then the confrontation clause under the Georgia Constitution and the federal Constitution may, I don't want to concede it, but that's why I didn't object. The reason I bring this up to the Honorable Court, I have no idea what this next witness may or may not say, but if she truly shuts down, I just want you to know that that's why I don't want it to happen in front of jury. I will be asking that nothing be said. You know, the prosecution cannot ask leading or non-leading questions, because if the answer is I'm not answering, then it's a confrontation clause violation. That's why I want to bring it to your court. But when I heard this, that you know, it progressed, but she's in custody. I knew something happened. That's why I asked Brady. We heard that then, and then depending upon what she says, I just want to alert you, Your Honor, that there may be a confrontation clause violation, which of course, you know, you asked us to tell you, which has to be harmless beyond a reasonable doubt. So it's the highest standard except for structural error. So I'm just letting you know, I have no idea what she's going to say, but it might be best practice to just ask her outside the presence of the jury, what's your intention? And if she says, I'm not here, I'm not talking with anybody, it's a dangerous thing to put in front of the jury. I'm just doing what you told me to. So I'm making that confrontation clause argument now. I know it's not right because I have no clue. She might testify, but if she doesn't, I'm just letting you know that, you know, I'm going to be asking to approach and move for mistrial and strike.
Your Honor, I would ask Mr. Steele too, if there is case law that even suggests what he is saying, that he provide us with the cites, because my reading of the law is entirely contrary to the notion that he is proposing to the court, that what happened with Adrian Bean implicates confrontation rights. So I would also ask the court to inquire of Mr. Steele if he has any recordings of this next witness.
Isn't that you surprised the defense with a lot of new facts, and you, Miss Love, yeah. Patty B asked Niklas, who is this witness? This is supposed to be the woman in the apartment where allegedly somebody she opened the door, something with a gun, a fire was shot in the apartment. The witness is Miss Bennett. And she was arrested yesterday for non-compliance to a subpoena. And she is currently probably in the court's back room with the prison garments. Yeah.
If he had an opportunity to interview her, and what she told her, what this witness told Mr. Steele or any representative for Mr. Steele, since he is asking the court, because I don't know what strategy there is. I don't know if it has ever been, and I'm not suggesting that he did it. I don't know if someone told her, just don't say anything. I don't know, but I certainly would ask that the court not bring her in here outside the presence of the jury and say.
Yeah. Again, this person, Miss Love, she has planned, in my opinion, speculatively, in my opinion, this is all planned out. She wants this witness in prison garments, might hoping for that this witness does Mr. Bean and recollects nothing. But Mr. Bean might have been, we don't know, maybe the jury went, oh, poor guy, lost his job because of this. She doesn't want that with this witness.
Ask her these questions and provide her an avenue. She has already indicated that she does not want to be here. For us to have to get a material witness warrant.
She's a reluctant witness. Does she have any type of criminal charges or anything that would?
She does not have her case happened in 2011, and she was sentenced as a first offender in 2014, I believe. And then that was in another jurisdiction. And then that was revoked when she got charges in Fulton. And all of that information has been turned over upon an open records request by Mr. Steele. So she was under sentence in.
Did you hear that? Mr. Steele had to more or less order, or via the court, via the system, order the prosecution to hand even that information over. Information that should have been given to them voluntarily. Thank you, JC, for your $10 super chat. And you say thank you. Thank you, JC. Much appreciated.
She was sentenced here in Fulton after she was revoked on the Clayton County charge. She is out of prison for that, and there are no pending charges against her. There's nothing. She doesn't have charges. Also, Your Honor, according to Allison, Allison versus the state 356 Georgia App 256 at 258 through 261, the Court of Appeals has said in 2020 that a witness's inability or unwillingness to recall specifics in their testimony does not make them unavailable as a witness for purposes of hearsay and confrontation clause objections.
You're not conceding that.
I said conceding that. You said that. Yeah. I said Mr. Bean testified. I don't recall. I said that's why I didn't object. I found one case in Georgia that said it's not confrontation clause. I told you it's definitely not hearsay. I mean, yeah, there's nothing to rebut. So anyway, I don't know. I shouldn't get frustrated.
No. I mean, do you have any other case law that would say it's a confrontation clause issue? As Mr. Steele, it looks like right now we're possibly faced with a witness that's reluctant. Would be probably the best term.
The way I understand it is it depends on how she acts.
Exactly. So
if she's, and I have no clue, if she sits up there, what's your name? I'm silent. Is your name this? Silent. That would be, in my opinion, a violation of the confrontation clause because there's no opportunity to cross. Different than, I don't recall, but that's a statutory right. And as I told you, in Georgia, there's a confrontation clause case that says it's not confrontation clause. So it just depends on what she says.
But she's here. I mean, and I could, depending upon what she does say or not say, allow her to be treated as hostile so that leading questions could be asked. She'll answer. She may not answer any of them.
Right.
I mean, and then you still have the right to examine her. I mean, but she may not say anything. I mean, that's the other thing that may happen.
And that's my issue that I brought to the court. If truly nothing is spoken, then I have a violation of the confrontation clause on behalf of Mr. Williams, Mr. Matthews Jr. et al. have that. I'm just trying to raise it to the court.
Yeah, in the interest of justice, I would ask the court to inquire of Mr. Steele if he has any information, any recordings of this witness, anything of that
Shut
nature
up.
that give him reason, or even if he doesn't give him reason, if he has any recordings, If he has any information, if he had the opportunity to.
Did you interview the witness, Mr. Steele? Did you have the opportunity to do that at some point in time? Because that does factor into whether or not, part of my analysis as to whether or not there's any other information.
Your Honor, I don't have to answer that question, but I don't mind answering ex parte on a sealed record, and the defense can come, but not the public and not the prosecution. So if we could go into your chambers, or everyone not with the prosecution, excuse me, not with the defense, be excluded, and not with the court staff, excuse me, not staff, the court's chambers, then I don't mind sharing with the court.
I'm not asking for anything that's privileged. I'm asking for an inquiry into.
Sit down and shut up, Ms. Love.
And whether or not.
Okay, been doing a bit of research. This is a 2013 case about this witness. This lady told the police that she got robbed by Thug DK and someone she thinks was Thug's brother. She did not call the police at that time. Sometime later, she hears gunfire outside of her apartment, calls the police to report the shots, and tells them about the robbery. But when the police tried to follow up on this, they were not able to get a hold of her. So the investigation was dropped. The statement still exists. And that's why they want her as the witness, because she is the only one they can bring the statements in on. This is an underlying act that never even was barely investigated back 11 years ago. But they bring it up here and they arrest the woman who may or may not have made a false statement back in 2013, just to get that in.
He made any recordings. I'm not asking for the content of those recordings, if he wants to call it work product or whatever. But I'm asking, in the interest of fairness, they are making assertions.
You don't know fair
and
if it
all
hit
sorts
you in
of,
the ass.
Requests of the court. I asked that the court simply inquire, one, whether Mr. Steele interviewed her, interacted with her in any way, and two, if he has any recordings. Whether or not the state is privy to those is an entirely different other matter that I'm not even reaching right now.
Your Honor, I'm not, I'll do exactly what I said, and your honorable court can listen, hear, view, read, whatever you want, but I'm not doing it in front of the state. I don't have to do that. And it's the same thing that Ms. Love did earlier. I don't have to do this, but I don't mind doing it. There's no wrongdoing here.
And Your Honor, they're not willing to do that, and we're just ready to call.
But you can't make these assertions and not do it with the court.
Yeah, and this witness should definitely have representation. Definitely.
All right, folks, please, let's not do that. Let's not get into any of that. All right, give me a second, please.
Your Honor, may I just step out to the bathroom?
Yes.
And they're on a break. Let's see what he says.
All right, it's clear we don't know what she's going to say. However, that's just the whether or not she testifies as to what, will be within her decision to do so and to testify truthfully.
The defense knew she was going to be testifying today. They had no idea whatsoever that she was reluctant, that she avoided a subpoena, and that she was arrested, and that she was put in prison clothes. No idea before 1 p.m. today, when the prosecution told the court. They had no idea this would happen.
My concern, or the court's concern at this point in time, is that you, being the defense counsels in this case, may not have had the opportunity to talk with her about what she is going to say. I don't know whether or not my concern, as well as based upon the state's proffer of what they have said to her, is it may or may not be impeachment, it may or may not be Brady. But I think in order for you all to satisfy yourselves, you should be given the opportunity to talk with her. So I'll let you do that over the next 30 minutes. So you can talk with her and see what she says. And then we can kind of take it from there. Those who are interested in doing so. So that's the court's suggestion. So I'm going to be in recess.
Your Honor, I want to make sure she's sufficiently separated from the defendants. I know that she's going to come out over there, but I would ask.
I'll let Sergeant Ingram and his colleagues facilitate that issue. Okay, won't worry about that. I'll let him and his team resolve that. Okay.
Okay.
Then, based upon what she tells you or doesn't tell you, I'll fashion or consider other things. But
Your Honor, given that she does not have to speak with anyone, Your Honor.
I'm going to give her the opportunity based upon what you've proffered. I don't know. I really don't know whether or not anything that you have said to her would be exculpatory or would be impeachment. But I'm going to let them decide whether or not they want to inquire about that, because impeachment can be Brady. So, but I don't know. We don't have a good handle on what she's going to say. So I'm going to give them the opportunity to at least go ahead and do that. They've had the opportunity over the last 3 months. They've known who the witnesses. They certainly, I believe that one counsel has probably interviewed her. And that might be Mr. Steele. The rest of them, I don't know whether or not they've done anything in that respect, but they have, and that's certainly something that.
And he keeps blaming the defense. But this is half a win. I will take that from this judge, that they at least get some time with her. And understandably, the state objects. And I would assume it is because they are a shady bunch of cunts.
They and their clients are going to have to take up. So based upon what you said, and just to make sure that there are not any, that they're authorized to determine whether or not, or anything that was said is a Brady or maybe a Brady, then I'll go ahead and do that this time.
Yes, Your Honor.
So we'll be in recess about 30 minutes, see where we are. Sergeant Ingram, you and your team will facilitate having a conversation with, is it Miss Beverly? Bennett, Miss Bennett. Okay?
Yes, sir.
All right. Okay. All right. So we'll be in recess for 30 minutes. And counsel, so those of you that wish to talk to Miss Bennett.
Let's see if it's 30 minutes. That's about 30 minutes. That 30 minutes turned into almost an hour. So we are only 10 minutes behind all of a sudden.
Yeah, all right. Thank you. All right, counsels, for those who have sought or had the desire to interview Miss Bennett, are we complete with that?
Yes, Your Honor. Good afternoon to the court. Again, Carlton Matthews on behalf of Mr. Marquavius Huey. Your Honor, based upon my discussions with Ms. Bennett, I believe that the court likely needs to inquire upon her in terms of an appointment.
Okay, that's why. Okay, so they didn't transmit that part. Okay, now I understand why those 30 minutes took an hour. They had this discussion without cameras or sound on. Okay. Let's go back a bit.
Huey. Your Honor, based upon my discussions with Ms. Bennett, I believe that the court likely needs to inquire upon her in terms of an appointment of an attorney. I believe that there could be some culpability issues that are going on with respect to some of the things that I learned from those discussions. And I believe that it would be in her best interest that she have an attorney.
Such as what did she tell you that would potentially inculpate her? Does it have anything to do with this case?
It does have things to do with this case, and I would have no issues with sharing that information ex parte with the court.
All right, come.
Oh, look at that. This technically is a sidebar. Sidebar counter 112! From the start of this trial, 112 sidebars. And for you who wonder, the for F's sake counter, we blew that out of the sky months ago. Hello, everybody who just joined. We are soon up to actual live. This is a clusterfuck. This is a long sidebar. How about that? We are live, and they are still at a sidebar. Heather Mosher, so she might actually made a false statement. That might be it. And I will assume that the prosecution knows it and they don't care. She made the statement, they want it in because it looks bad for the defendants. And I assume that, I hope that this judge grants her representation, because if he does, this court day is over. And probably, I don't know about tomorrow. It's Good Friday. It's not a holiday in the United States, which is amazing for the rest of the world, who still celebrates all of Easter. That one of the most Christian countries in the world, the United States, does not honor Good Friday in some states. Well, she's an adult. She can waive counsel. But I assume Gwendolyn, has this witness testified already? No. The prosecution had her as a witness today at 1 p.m. And then they broke the news to the defense that she was arrested yesterday for not complying with the subpoena. She was in prison jumpsuit and threatened to end herself if she had to testify. Yeah, that no consent, but if she is not informed that she had the right to have a lawyer, yeah. Here's the thing, she's in custody. She does not have any charges. It might be that it is the prosecution's and the police interpretation that she doesn't need to be Mirandized. So she might not know she can actually have a lawyer. Are we waiting for the 8th? No, we are waiting for the sidebar to end. Because, yeah. Helen Jennison, did you look it up? Mr. Steele dropped a complaint at the bar about the judge 6 years ago. I made a quick Google and I saw references to it, but I don't know what it was about. But yes, Mr. Steele 6 years ago made a bar complaint about this judge. And for a lawyer to make a bar complaint against the judge, that's a rough one. And in about 12 minutes on my secondary channel, I will be, my next video is up. For you who don't know about my secondary channel, it is The Elderman. I read old Scandinavian stories, sagas, and folklore. And in about 13 minutes, today's story is the Viking goddess of Easter. You didn't know we had one, did you? Well, you will find out. And her name is... Eistre. So if you didn't know, the word Easter comes from Old Norse Eistre, who is North Germanic and Anglo-Saxon goddess of the spring, of rebirth, and stuff like that. You didn't know that, did you? Well, now you do. This sidebar is taking a long ass time, and I kind of understand why, because this judge so far, for months, have done anything to bring this trial forward, and he blames the defense for the delays. But here's the thing: the person who is late all the time is him. Every morning when he says, "Oh, be here at 9 for a 9:30 start," and then everything from 15 minutes to 90 minutes later they start. And that is because this judge doesn't control his courtroom. Mamaro, how the F is she in custody without an opportunity for a lawyer? Well, she doesn't have any charges. The only thing, they have arrested her for not honoring a subpoena. They might think that that is not an offense that needs to be Mirandized. So she might not know she can. Here's the thing, folks. You always, in the presence of law enforcement, call your lawyer. Get a lawyer. Ask for a lawyer. Always.
Christian. Hold on.
Yes. Yes.
Yeah. Oh, I can show you this instead. This is the Wheel of Regrets. So far, we have $10 in super chats in. For if we get another 40, if we get 40 more, I will spin this wheel. Or I might just do it anyway, I don't know. But if you want to sponsor this channel, do so via super chats, gifted memberships, becoming a member. It's $3 a month. Or if you don't want to sponsor YouTube's with a lot of money, you can use PayPal. PayPal only takes like somewhere around 2, 3, or 4% cut, while YouTube's takes at least 30%. Let's get back here. Let's listen to the judge.
Seats. Sergeant Ingram, can you go ahead and summon our jurors for us, please?
Here we go.
Oh, I need to rule upon one other thing. I am going, where's? Okay, hold on one second. All right.
Kendrick. That's it.
Get her representation, judge, for frick's sake.
Everybody see it.
No, this is not Mr.
All right,
Bean's wife.
Sergeant Ingram, all
Mr. Bean's wife
participants
is
present,
not
sir.
a witness in this trial.
Yes, sir.
Okay. To the members of the media, if you would be so kind as to not place our next witness's facial video of her, you're welcome to audio tape and otherwise use any other medium at this point in time. Okay. Sergeant Ingram, summon our jurors for us, please.
This is insane. Give a representation so that representation can tell the court she needs out of that prison garment immediately. But it's the judge's discretion, and he kind of wants her in prison garments, even though it's not needed. We are live again. Yashun Richardson, that's not funny. I don't want any sausage crap here. Not even as a joke.
All right, ladies and gentlemen, please be seated. All right, Sergeant Ingram, all our participants. All right, thank you, sir. All right, ladies and gentlemen of the jury, good afternoon. Good afternoon. All right, again, like what has happened on a few occasions, took longer than we expected for our work outside your presence and hearing. So we'll continue at this point in time, and we thank you so much for your patience with us. All right, State, call your next witness.
The state calls Mr. Bennett.
All right, summon Ms. Bennett, please.
And she's been walked in with prison garments. This is infuriating. How the judge even allows this to happen. Thank you for reminding me, Council Moon. Mr. Short wanted to hold up a prison uniform to the jury in opening statement, saying the police acted like a gang. Wasn't allowed to. Here's the prosecution dressing a witness in prison clothes. They didn't even offer her the possibility of civilian clothes because they are cunts.
All right, Ms. Bennett, if you could please approach the witness stand. Good afternoon. And before you sit down, turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. Test your ability. You swear affirm the testimony you give today the truth, the whole truth, and nothing but the truth?
Yes.
Have a seat.
All right, Ms. Bennett, if you could, pull yourself up as close as you can to the microphone and speak directly into it.
State and spell your first and last name for the court. State and spell your first and last name for the court.
Okay, what's your first initial, madam?
A.
And could you spell your last name for us?
E-E-N-N-E-T-T.
All right, thank you.
And Your Honor, with the court's permission, as long as it's been in promises that nothing will happen if we do so, we'd like to have the cuffs removed from her.
Oh, you
Yes.
fucktard. You fucking twat. You got her in shackles and prison. Oh, you fucking cunt. Oh, you such a cunt. Oof.
May we have the cuffs removed from this man?
Yes, ma'am.
Deputy Ms. Bennett.
Good afternoon.
Ms. Bennett, you and I have had a chance to speak before you come into court. Is that right?
Yes, briefly.
And that was last year, before the 2024 came. Is that right?
No,
I'm gonna allow it just a little bit, Mr. Adams.
Have we met more than once?
no,
Do you recall meeting with me and an investigator with our office in a Wendy's parking lot on Roland Avenue?
yes,
And have we talked outside this courtroom in the hallway
briefly.
briefly?
Yeah.
Now her mic just went out, Your Honor. Is it working? You said briefly?
Yes.
Now, let me start off by asking, do you want to be here today?
Objection, relevance.
I'll overrule the objection. You can answer the question, madam.
No.
Judge, I think there is something wrong with my phone.
Yeah, it may have
Oh, it's going in and out. And go ahead. Do you want to be here today?
I
Go ahead and
answered.
answer it. I'll overrule the objection.
Answer it again.
You can answer it. Yes, ma'am.
No.
And are you here voluntarily or were you forced to come here?
I feel like I was forced to come here.
And Ms. Bennett, I apologize, but we had to have you come in and we had to have you.
Hold on. Mr.
No.
Matthews and then Mr. Adams. What's the? Oh, I'll sustain the objection.
Ms. Bennett, do you understand why you were calling here to court today?
Not really.
Ms. Bennett, did you grow up in Atlanta?
Yes, ma'am. Born and raised.
And what part of Atlanta did you grow up in?
When you say what part, like, I lived in a lot of parts of Atlanta.
Say that again.
I lived in a lot of parts of Atlanta.
In 2013, Ms. Bennett, where did you live?
I'm Confederate.
Judge is going in and out.
Hold on. What's the basis for?
Judge, I think if I may, it literally, the sound is going in and out as she speaks.
Let me, Ms. Bennett, if you feel comfortable, do you mind taking off your mask? If you can, if you'd like to. I think we'd be able to probably hear you a little bit better. But that's up to you, madam.
It's
If you,
the audio,
No, no, I only got on the mask because within the last 7 days, my grandma, she just had COVID and I just did my test. So they told me wear a mask.
okay. All right. I think that answers that question, Mr. Adams.
Judge, I think it's the audio, it literally keeps going in and out from where I'm standing. So, Ms. Bennett, if you. can
Maybe
talk
it's wrong
loud
with
enough
your
so that I can hear
hearing,
you
please.
without even having the microphone, can you do that for me?
I'm talking loud as I can.
Independency, miss. I've got the same kind of issue with my mic. I don't think it's coming through it's kind of coming in and out. Let me make a phone call.
It's a technical issue in the courtroom. For you who have seen me and Dave with our classic trials,
Hey, can you have
none of these issues.
tech come over and troubleshoot our speakers? Because they're not coming, sound seems to not be coming out of them. Then you're doing right now, it needs to come over, okay? All right, thank you.
All right, let's try let's try as much as we can. My mic seems to be working. Let's try yours again, Ms. Bennett.
Testing.
Good. All right. Don't touch nothing. Nobody. Nobody. What'd I tell you, Mr. Matthews? You don't touch nothing. All right, let's see if we can kind of get through. Sorry, go ahead, madam.
Ms. Bennett, without giving names, just in relation to you, if anyone, who lived with you in 2013 on Confederate Avenue?
Repeat it again.
What relations, what relatives of yours live with you in 2013?
Oh, my kids and my kid's father.
How old were your kids in 2013? How old are they now?
Well, I have a son that was born in 2013,
And what month was your son born?
January.
So on Mother's Day 2013, you were the mother of 2 children.
Yes.
Now, how long had you lived at Confederate Avenue by the time 2013 came around?
I'm not sure.
Did you live in an apartment, a house, or something else?
Before I lived on Confederate.
On Confederate? What
Oh,
kind of-
apartment.
What was the name of those apartments?
Trust Street Village.
Ms. Bennett, I'm going to approach you and show you what has been marked as State's Exhibit 1 Alpha Alpha.
Have you already shown that to defense counsel, madam?
I have a copy.
All right.
They have been served previously.
All right, well, let them take a look at it before you approach the witness.
Yes, Your Honor.
Okay.
And we did send to them the PowerPoint that has all of these exhibits. in it. So I'm showing 1 Alpha Alpha counsel. Your Honor, I will approach the court. Ms. Adams?
Yes.
Yeah, you can keep that.
Okay, you may approach.
Thank you. Ms. Bennett, I'm showing you what has been labeled as State's Exhibit 1 Alpha Alpha. Do you recognize those apartments that are pictured in State's Exhibit 1 Alpha Alpha?
It's kind of look similar unless they did a little different work to it.
When you say this kind of looks similar, what do you mean?
Like the layout of the building kind of looks similar.
And now I'm going to show you what has been labeled as State's Exhibit 8 Alpha Alpha. Do you recognize State's Exhibit 8 Alpha Alpha?
It looked like a door.
Is it your testimony that you do not recognize it?
No,
It is not your testimony?
I just know it looked like a door.
Okay. Do you recognize State's Exhibit 13 Alpha Alpha?
No, ma'am.
What about 14 Alpha Alpha?
No, ma'am.
15 Alpha Alpha?
Is it something I'm supposed to be looking for in it so I can know what it is?
You're just supposed to tell the jury whether you recognize those photographs
Oh,
or the items depicted inside the photographs.
no, ma'am.
State's Exhibit 17 Alpha Alpha.
Yeah, folks, hit that thumbs up. It's free. And it's the one thing I actually ask for. Giving the thumbs up. Everything else like super chats, memberships, that's voluntarily, but these I actually ask you for. So please do. Thank you.
No, ma'am.
State's Exhibit 20 Alpha Alpha.
No, ma'am.
State's Exhibit 22 Alpha Alpha.
No, ma'am.
No, thank you. I'm gonna take these back. Ms. Bennett. How old were you on Mother's Day of 2013? Let me just ask you this. What year were you born?
86.
86? And were you working during that time outside the home?
I don't remember.
Were your parents, was your mother alive in 2013?
You had to ask me like that about my mother.
Ma'am?
Why you say, was she alive?
Or-
Like,
Did you have
Overruled,
a
sir.
family? Did you have a family structure around you in 2013? Ms. Bennett? Your Honor, could we? Ms. Bennett, I'm going to move away from that and I'm going to talk to you a little bit about the first time that you and I met, okay?
Good idea, Miss Cunt.
Do you need a moment?
Ms. Bennett, just let us know.
Yeah, I said this earlier. I will say it again. Miss Love planned for this all along. Making sure this witness never felt safe. Making sure anything. Met once. Didn't ask about calls. Stuff like that. Knew she didn't want to come in to testify. So yesterday she had her arrested. And forced her to spend the night in jail. In prison clothes. Got stripped. Put in prison clothes. Was never offered civilian clothes to court. Was brought in shackles, handcuffs, and prison clothes. And now ADA Love stands there speaking softly as if she isn't the sole reason this poor woman is there.
You ready, okay?
I'm ready, but did she really have to do that, like, for real?
You're subject to examination.
I
But just let us know whenever you feel you're ready to go forward, okay?
I'm ready to. I talked to Ms. Love about my mom like that. That's a tragic situation for me. Like I haven't talked about this. I haven't grieved about this.
Okay, all right, go ahead, man.
Yeah. Miss Love knew. Apparently, Miss Bennett's mother died recently. This is evil. Pure evil.
Listen, I'm gonna wait until you tell me that you're ready to move to court.
come on, my love.
And I apologize for bringing that.
You ain't even got to apologize. I know you did it on purpose. It's all good.
Let me hold on 1 second, Ms. Love. I'm just 1 second.
Yeah. I agree with this witness. Miss Love did that on purpose. She knew about the reaction. And I actually think YouTube agrees, because somehow my monetization is still green. And the one thing the defense, when they get to cross, is to make sure everyone in that jury will find out how absolutely needlessly this piece of testimony is.
All right, Ms. Love, thank you, ma'am.
Yeah, I am amazed too, but let me show you. See? Monetization on, green. Now, what I haven't done is this add thing yet. I haven't chosen, so it's just green. Now, will you have ads? I don't know. Probably, maybe. I don't know. You tell me. But I'm amazed. I'm green.
Ms. Bennett, I'm going to ask you this question. Were your children and your children's father the only people who lived with you in 2013?
Yes.
And during that time, how far away from your mother did you live?
What? Jesus, this better be the
Approximately
most.
about 12 minutes.
This better be the fucking most important
Did you
witness
talk
in
to
this
her?
entire trial, you cunt.
Every day.
And on Mother's Day in 2013, did something happen to you that caused you to later make a report to the police?
Not that I recall.
Bum, bum,
You
bum.
earlier said that, or referenced when you spoke to me. When you and I spoke the first time, did you tell me about some things that you had gone through?
Yes.
Did you tell me essentially that the state had let you down?
Mr. Sherrod, I'm gonna overrule your objection.
Of
Did you tell
course
me
you are.
essentially that the state had let you down in a number of ways?
No, when I talked to you, that's like the first time I talked to the state.
And when you say the state, are you talking about the district attorney's office?
Or unless you stating like me being locked up and stuff, and I told you that, yeah. Yes. Yes.
And you spoke to me, or did you speak to me about getting some tragic information while you were locked up?
About when I was locked up? Yes.
And did that cause you to have any feelings of resentment towards the state?
I'll overrule the objection, Mr. Matthews. I'll make it a continuing objection. Overrule, sir.
You may.
Of course you're going to overrule, Judge,
You
because you're a
repeat.
biased piece of shit.
Did what happened to you have an effect on you and your feelings towards the state?
Yes.
How did they affect your feelings towards the state?
Also, I make objection on foundation.
Overrule, sir.
Mhm.
Do what Dave says. Hit the like button,
It just
folks.
made me feel like, like they weren't trustworthy or something. Like a lot of things had happened.
I'm sorry that you were made to feel that way.
No, you're not.
When was it that you were?
I'm going to object and answer that last statement from the state stricken. That's a vote.
I'm gonna overrule the objection, Mr. Adams.
Jesus fucking Christ, you biased piece of shit.
When was it that you were locked up, as you just referenced? What year?
2013, 2015 to 2017.
In 2015, is that when you went to the Department of Corrections?
Yeah, I went to prison.
In 2013, were you in prison?
No, I was in Clayton. I think Clayton.
In 2013, were you out on bond for charges in Clayton?
I can't remember if it was Clayton or Fulton.
I'm going to show you what I will have marked as State's Exhibit number 28. Alpha Alpha. And I'll ask you to take a look at it. And I'll ask you if this copy of documents from Clayton County, Mr. Adams, you want to refresh your recollection?
Here we go. This isn't a sidebar. They are just reading whatever piece of information the state. Hopefully, this is something the state actually turned over.
And you don't have provided these documents to us. I
Okay,
just want to be able to look at what you're trying to do.
all right. Oh, you're welcome. You may approach the witness now.
Thank you, Judge. Ms. Bennett, I'm showing you a document from Clayton County that I've marked as State's Exhibit 28 Alpha Alpha. Would you look at,
This is probably the statement. We talked about it earlier. So in 2013, she heard gunshots outside of her apartment. She called the cops. The cops showed up. Then she said something of the sort, somebody got into her apartment, fired a gun inside the apartment, and that person would be Mr. Thug, DK, and one more. And that was it. Never fully investigated. Nobody was charged, arrested, no nothing. So all the state has is that statement that has never been proffered. It has never been investigated by the police. It's just a statement.
this document on the page that I've labeled, or that is labeled accusation, and then look at the counts. Tell me.
She can't, parties can't hear you, Ms. Love.
Okay, thank you. Ms. Bennett, would you look at the document and tell me if it refreshes your memory as to whether or not your charges in 2013 were from Fulton or Clayton?
Oh, are these her charges? What does that have? Oh, Jesus Christ. Why is this witness there? Well, we know about a statement in passing to cops that was never followed up on or fully investigated. But it's still being brought up here in trial. Who knows? She might just be disgruntled. She heard the shots, thought, now I'm going to nail these
Ms. Bennett,
bastards.
let's take as long as you
Then
need to
made
look at
something
that
up.
document. When you're finished with it, let Ms. Love know, okay?
Okay.
Your Honor, the next document that I will show the witnesses is Exhibit 29 Alpha Alpha. I will allow defense counsel to look at that while allowing Ms. Bennett to look at 28 Alpha.
Yes, they say I was
Don't read it out loud, just let me know if it kind of refreshes your memory about the charges you were facing in 2013.
yes,
Were the charges that you were facing in 2013 out of Clayton County or Fulton County?
this right here is Clayton.
And did those charges happen? In other words, did whatever it was that led to those charges, did that happen in 2011?
No,
When did that happen?
this happened in 2013.
So were you out on bond for those charges on Mother's Day 2013?
I'm not sure.
2013, Mother's Day. Did you own a firearm?
What year this was?
If she somewhere around 2013 had a felony conviction, she can't own a gun. But nobody is objecting. And this is why she should have had her own counsel, her own attorney, that could advise her to what kind of questions to answer, not to answer. And this judge, no, not going to happen.
2013.
In 2013. Yeah, I think I owned it maybe 2 firearms.
And what type of firearms did you own in 2013?
I really can't remember because I know the state, I think that's what you call it. They had one of my firearms in custody. I think I had to turn it in or something. Yeah, but I don't know which one.
Do you recall whether you owned a Kel-Tec pistol in 2013?
I'm not sure.
In 2013, would you tell the jury the last name of your child's father that you lived with? Just the last name and first initial.
Anderson.
And what was the first initial?
M.
On Mother's Day, May 12, 2013, was your child's father friends with defendant Jeffrey Williams?
I'm not sure. Was they friends or not?
Do you know who Jeffrey Williams is?
Now I do.
What do you call him?
Thug.
What did you call him in 2013?
Thug.
Do you recall when we met that you told me that your child's father was friends with Jeffrey Williams in 2013?
No, I didn't tell you what year. I told you that they did a video together, but I didn't know what year they did it.
And what video was it that they did together?
I don't know,
How do you know that they did a video?
because I seen it.
Were you there while it was made, or did you just see it on YouTube or something else?
I seen it on YouTube.
And do you recall what song or what it was that they talked?
This is establishing the connection between her, Young Thug, the association, blah, 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 blah.
About in the video?
No,
On May 12th, 2013, did you know a person called DK?
no,
Did you report to the police on May 13th, 2013, that you knew a person by the name of DK?
no,
Did you report to the police in 2013 on May 13th that you knew a person named Thug?
no,
Let me ask you this. You said you now know who Jeffrey Williams is. Are you afraid of Jeffrey Williams?
no. I know who he is.
Hold on,
'cause y'all told me.
hold on, man, hold on. All right.
Yeah. Remember, this witness has continuously said it's the prosecution. And still, this fucking cunt asked this witness after she had put her through hell if she's afraid of Mr. Williams. That is so out of line, so unethical. But that's the evilness in Assistant District Attorney Love. Mistrial, they will ask for it and they won't get it because this judge is adamant to see this trial through. He doesn't care how many rights are violated, how shit the prosecution's case is. I assume he's on the prosecution's team, on the bench. Yeah, Heather, she's afraid of Miss Love. Because even though this incident has been known for years, the alleged incident, nobody has done anything to her except the Assistant District Attorney, Love. Yeah, this witness threatened to self-delete because of Miss Love. Sidebar counter 113! Yeah, sorry, I can't do the fun sidebar counter at the moment because this is what should be reported to the Georgia State Bar.
I haven't said anything yet.
Yes.
Yeah, this is infuriating.
I'm sorry, I was supposed to be able to hear this. If you can't hear.
Get the jury the fuck out, Judge. Thank you, Twiddly Pope. Still loving my Count Dracula. Yeah. You never ask the witness, are you afraid of that person or this person? You can imply, have the prosecution done anything to scare you? Yes, no, or what? But the prosecution asking, are you afraid of Mr. Williams, is unethical to the core. Yeah, no, she laughed and said no. That was a good response. But that question never from the prosecution. Never. Well, yeah. I have my clickety-clackety still keyboard. It has colors. Oh, this is the shit show of shit shows, Eric. The prosecution just asked the witness, are you afraid of the defendant, Mr. Williams? You are not in. There's no place for that question in any court. You might as well call it a day, Judge, because this is... And we are live.
Yeah, I think we fit that problem. Y'all got a problem hearing now? Don't worry about it. You definitely you know what it is. Yeah, we're good. Okay, we'll call you.
Oh, over 2 hours. Shit, fuck, cunt. It's- hello, Victoria. Greetings from Tucson, Arizona. Sorry, you just got here for my rant, my 2 hour, all the words I can't say. Let's see here. My monetization is still green. I don't get it, but I don't mind. I have no idea. I assume the YouTubes agree with me that Assistant District Attorney Love is a full-blown evil cunt. Mr. E409, Texas in the house, Texas! I'm going to Houston in August, just so you know, for the Matsuri convention. And then I'm going to have a road trip. Houston, South Coast, up to Atlanta, up to Delphi, and then up to Michigan. Shelby, Texas here too. Oh, we have a Texas convention in my chat. I've been to Houston, I've been to Galveston, I've been to Dallas. Now I'm going to Houston again. I like Texas. If I didn't lose so much money in retirement funds because in Europe my retirement funds, some of it at least, the majority of it is in government blah 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 retirement fund. And if I move to Texas, West Texas, I will lose that part. But if I could, I would. Oh, Mr. E409 is in Galveston County. Nice. I went there in 1996. And we went to that aquarium where all the parrots and fish are. And then it was in April. So it was before tourist season. So not much was open. Lovely place. Lovely place. Indianapolis Motor Speedway. Where's Indianapolis? Oh, it's a city in Indiana. Yeah. In Indiana, I am going to Delphi. And I'm also having a meetup with Mo in the Deep End. And probably Kaiser Pineapple as well. Kaiser Pineapple is a YouTuber, for you who don't know. He does movies, reviews, and conspiracy theories. Cool guy. That's a long hike. Yeah, it's going to be amazing. I'm flying in August 6th. And then the convention is August 8 to 11. And then on August 12th, I'm doing the road trip. And I will try when I get to Atlanta to get into this courthouse. Team Eagle, why did she ask for that? Because ADA Love is a cunt. Call it as I see it. Now, maybe down the line, YouTube will punish me for doing all the words, but they don't now. Just cause says, be safe, Atlanta is a shithole, dude. Yeah, I know. I know. Come on, George. Throw it out. Get rid of it. But just Miss ADA Love, I am making a motion of off you fuck. And that is because you are a cunt. I think that is a legal definition of what he should do to this prosecution. Lynn Hall, right. What was point? Asking if her mom was alive in 2013 had nothing or no bearing on follow-up questions. Exactly. She's a sadist cunt who likes getting the witnesses to cry.
All right, you may continue, Ms. Love.
Thank you, Your Honor. Ms. Bennett,
No, oh Jesus, fuck. Okay, so the jury was there all along. Okay, and no instructions to the jury. This is why this trial will never have a mistrial. Because this judge, I don't care how competent he was before this trial, he is unfit to the core to even be in a courtroom the way he is handling this trial.
do you recall going to the police station at Zone 3, the Zone 3 precinct, on May 13th, 2013?
No,
Do you recall how far the Zone 3 police precinct was from Trestle Tree, where you lived, on May 13th, 2013?
no, I'm not sure how many minutes.
Say that for me.
I'm not sure how many minutes it is away.
Do you know where?
10,
it was?
12, something.
10 or 12 minutes away?
Yeah.
And is that on foot or in a car or something else?
On foot, it's probably longer. Probably about a good 20-some minutes or something. Yeah.
And how was it, or how is it that you're familiar with where the Zone 3 precinct is, or was in 2013? Tell the jury.
Say it again.
How are you familiar with where the Zone 3 precinct was in 2013? If you just tell the jury.
The precinct is by the zoo.
And you had seen it with your own eyes.
I'm from Atlanta.
I'm gonna take that as a yes. Is that all right?
Yes.
Do you recall walking to that precinct on May 13th, 2013, the day after Mother's Day?
I wouldn't have no reason to walk. I had a car.
What type of car did you have at that time?
A Porsche.
A Porsche?
Yes.
Do you recall taking your youngest child, the one that was born in 2013, with you to the Zone 3 precinct on May 13th, 2013?
No, what you asking me is the same thing that I'm saying no to.
Do you recall speaking with an investigator at the Zone 3 precinct on May 13th, 2013? And I hear what you're saying, but I have to ask the question, okay?
Well, I don't know how to answer the same thing over because you asking it in different ways. So I don't know.
Your Honor. Ms. Bennett, I understand what you're saying, but I still have to ask you the question.
No.
On May 13th, 2013, do you recall riding in a car with your child and police investigators from the Zone 3 precinct?
Say it again.
Do you recall riding in a police car with your child from the Zone 3 precinct back to Trestle Tree?
No.
Do you recall telling the police that you were at home on Mother's Day at around 1:00 p.m.?
No.
Do you recall telling the police that on Mother's Day, May 12, 2013, you heard a knock at your door?
No.
Do you recall telling the police you asked who it was at your door after hearing a knock?
No.
Do you recall telling the police that you learned after asking that it was a friend of your child's father, known to you as Thug, who was at the
Objection.
door?
Prosecution is testifying.
Do you recall telling the police that you opened the door and let Thug inside your home?
No.
Did you ever say to the police that Thug's brother was also with him?
No.
And do you recall telling the police
Remember,
that you turned your
this
back
incident
on
is
Thug,
not
Thug's brother,
an
and the
underlying
person
act
you
in
called
the RICO
DK
case
after letting them in your home?
because never investigated properly. Nobody charged. Nobody. Imagine the cops who says this happened. They get to an apartment with this lady who claims 3 men came in and fired gun or whatever's. And then after that, you did nothing. And then 11 years later, here we are.
No.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Did you tell the police that the 2 suspects, along that Thug, his brother, and DK demanded money from you and your gun?
No.
Did you report to the police that Thug, DK, and Thug's brother took your Versace necklace and approximately $100 off your kitchen table?
I never owned a Versace necklace.
Did you tell the police that they also took $4,000 and your rental car keys?
No. I thought you just said they took $100.
Off the table. And in addition to that, they took $4,000 from you and your rental car keys. Do you recall telling the police that?
No.
Do you recall telling the police that they placed your items inside a brown baby bag that also contained your red Dre headphones?
No.
Did you tell the police that DK took your Keltec model PLR 16 223 pistol?
No.
Did you tell the police that before leaving your apartment, DK fired a shot from your own gun into your living room wall?
No.
Did you tell the police that you waited for a long time before leaving the apartment after that happened?
No.
Did you tell the police that you stayed in a hotel for the night after being robbed by Thug, his brother, and DK?
No.
Did you tell the police that a neighbor told you that, Your Honor, we're not offering for the truth of the matter asserted, we're offering it for the impact on the listener, which was Ms. Bennett at the time.
That's already been ruled upon, Judge.
Your Honor, we are asking whether or not she told this to the police. And
Thank you, Mr. E409, for your $5 super chat. Salute. Thank you so much. Now we are $35 away from a spin of the Wheel of Regrets. It's either whiskey shot, gin shot, vodka shot, sour shot. Yay! I have Good Friday off, and I can cure any hangover within days.
whether she explained that as her reason.
I'm on an overruled objection. I'm an overruled objection. As to that, but this question is proper to be asked.
Did you tell the police that a neighbor informed you that they had returned around 4 a.m. and shot up your apartment, and that is why you came a day later?
No, it wouldn't make sense to come a day later if I was robbed.
Did you tell the police that you only went to the police after talking with your mother, who convinced you to do so?
No,
Did you tell the police that the phone that was stolen from you was a HTC Boost mobile phone?
I never owned a Boost mobile phone.
Did you tell the police that the phone number of that telephone that was stolen was 404-734-7358?
No, ma'am. The phone I have, I've been having the same number since, I think, 05 or 06.
Did you tell the police that Thug, DK, and Thug's brother were answering your stolen cellular phone with that phone number?
I don't think that'll make sense, no.
Did you tell the police that all three, Thug, his brother, and DK, were out with your child's father the night before?
Wow! Becky Lynn, for some odd reason, $77. Thank you. Thank you. Says Niklas, you're one of my favoriteest channels and certainly among the best hosts ever in the history of YouTube. You and Master Jingles too. Thank you so much. Did you hear that, Mr. Where did you go? What? Mr. Jingles is out there somewhere. Thank you so much. Thank you. That's so sweet of you. And that brings us to a spin on the wheel. Vodka shot. Ta-da-da-da. Oh. Nom, 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 nom. Oh. Oh, thank you so much. Back to the trial.
No,
Did you tell the police that they left the scene in a blue Dodge Challenger and a brown four-door, or possibly a Nissan?
no,
Did you show to the police the bullet holes in your apartment?
no. Police never came to my house.
Did you tell the police that you reported the incident the next day because you were afraid and you know Thug, DK, and Thug's brother?
No,
Did you tell the police that during the robbery, only one shot was fired?
no,
Did you tell the police that the one shot that was fired was into the living room wall behind your couch?
no. I thought you said it was somewhere else, but no.
Did you tell the police that the other holes in your wall were from when they later returned?
Wait. Which part we talking about? Because it's confusing. You said I had one bullet hole, then now you're saying that I had some more. I don't understand what you're saying.
Did you report to the police that they shot up your home, according to your neighbors, at 4 a.m. on May 13th?
Yeah, my home was shot, but I never reported to the police that I did.
Did you show to the police a picture of Thug and DK on your cellular phone that you did still have?
No,
Did you tell the police that They later called you and apologized for doing what they did. And by they, I mean Thug, DK, and Thug's brother.
You just said they had my phone. How they called me?
Ms. Bennett, did you have more than one phone on May 12th, 2013?
I just said I've been having the same phone and phone number since like 2006.
You didn't answer that question for me?
I don't understand.
I'm
I
overrule the objection.
Of course, you're going to overrule the
Did you
question.
ever have,
He said, did I ever have 2 cell phones? I said no already.
did you have a Metro PCS cell phone?
I still have it.
And
Well, y'all have it now.
what does that Metro PCS cell phone look like?
It's an iPhone.
It's an iPhone?
Yeah, ma'am.
What iPhone? What type?
Apple.
iPhone 1, 2, 3, 4, 5.
What I got? Probably 13, 14, something like that.
And is it your testimony that you had an iPhone 13 in 2013?
Did I have an iPhone 13 in 2013? My iPhone 13 was not in 2013.
Okay. So is it fair to say then that that cell phone, that Boost mobile cell phone that you had in 2013 is not the same one that you currently have today?
I didn't have Boost. Then you just said I had Metro. I've been with Metro since like 2005, 6 or something, and I've been having the same phone number.
But you didn't have the same phone, did you, in 2013 that you have today?
I'll sustain.
Every year,
Hold on,
iPhone drop.
hold on, Ms. Bennett. All right, I'm gonna sustain the objection. You can rephrase.
Thank you, Judge. Did you have the same phone in 2013 that you have today with Metro PCS?
I couldn't have.
Did you have a Samsung phone with Metro PCS in 2013?
No, ma'am.
I'm showing you State's Exhibit 23 Alpha Alpha. And I'll ask you if you recognize the items depicted in State's Exhibit 23 Alpha Alpha.
What you mean?
Do you recognize what is pictured in State's Exhibit 23 Alpha Alpha?
Do I recognize the picture?
Do you recognize the items depicted in State's Exhibit 23 Alpha Alpha?
Oh, no.
Do you recognize the people depicted in 23 Alpha Alpha?
Yeah, him?
I'm over.
Either one of them.
I'm over.
Yeah, him. So,
And you're pointing to someone. You recognize one of the people in 23 Alpha Alpha?
you just asked
Well,
me.
hold on, Ms. Bennett. Let me rule upon the objection. I sustain this to form. You can just rephrase, madam.
Yes, Your Honor. Do you recognize at least one of the people in State's Exhibit 23 Alpha Alpha?
Yes.
Which one?
Thug.
Who?
Thug.
Do you recognize the hand that is depicted in State's Exhibit 23 Alpha Alpha?
A hand?
I'll show it to you.
No.
How long have you known Thug?
I'm not sure.
Did you go to high school with him?
No.
Did you know him when you were in high school?
I'm pretty sure I'm older than him. I ain't go to high school with him, so he couldn't be in high school with me.
How old are you? I hate to ask if you know. How old are you? Would you please tell us your age?
I told you when I was born.
I know, but I need the record to reflect your words. How old are you now?
I'm 37 now.
And why are you so pretty sure that you're older than Thug?
I'm just pretty sure I am.
Why do you think that?
I'll allow it.
He
Mr.
seemed young.
Matthews.
He seemed younger than me.
Now, you're nodding your head as you speak. What are you motioning towards when you said he seems younger than you?
He seemed younger than me.
Are you motioning towards anyone in particular?
You just asked me about a person. I told you that person seems younger than me.
Where is that person in the courtroom right now?
He's sitting over there.
What is he wearing?
I don't know. I can't really see him like that. Somebody in front of him.
Who is he sitting next to? Describe the two people on either side.
A man with a brown suit and a man with a gray suit.
Is the man with the brown suit a black man?
Bless you.
Yeah,
Wins Clotho, $5 super sticker, and it is a plant saying hello, or two plants waving. Hi. Thank you. That brings us to $3 to the next spin. Yay. Thank you.
talking about race now.
Okay. And the one with the gray suit, is he wearing a red tie?
Yes.
Your Honor, with the record reflect that she has identified the defendant, Jeffrey Williams, as
Yes,
the
Your
person who she is referring. And this been, is that the same person that you're referring to as Thug?
Yes.
Ms. Bennett, when you had charges in Clayton County, did you have charges with your child's father, Michael Anderson?
Yes.
And the charges that you had in Fulton County, were they also with your child's father?
I don't think so.
The charges that you had in Fulton County, are those the charges, or at least some of the charges that you said you went into the Department of Corrections for in 2017?
No, I got out in 2017. I ain't going in 2017. I told you I went in 2015.
Thank you for correcting me.
It's okay.
Are the charges in Fulton County the ones that you went to the Department of Corrections for in 2015?
Nah, Clayton.
Did you ever go to prison for the charges in Fulton County?
I think it was both.
So you went to prison for the charges in Fulton and in Clayton County when you went in 2015?
I think so.
Ms. Bennett, is it fair to say you never said anyone kicked your door down?
Have anyone ever kicked my door down?
I'm asking a different question. I apologize if it's not clear. Is it fair to say that you never reported that Thug kicked in your door on Mother's Day?
No, I never reported he kicked in my door. You said I reported that I opened my door. I can't open it and he kick it. And it don't make sense.
And that's why I said, is it fair
Yeah.
to say that you never reported that he kicked in?
No,
And is it fair to say that you never reported that you were shot on May 12, 2013?
I never been shot. Unless y'all know something I don't know, because I ain't never been shot.
Ms. Bennett, thank you for being patient with us. Give me just a moment.
How about motion of off you fuck to Miss Soulless Cunt
Now.
Love?
Ms. Bennett, when you met,
Yeah, folks, 261 watching over on YouTube, another 80 over at Twitter's, 168 likes. Seriously, folks, you have been here for 2.5 hours, some of you. I need that thumbs up. Here's the thing. If we get to 200 likes, I will take another shot of whiskey. Okay? 200 likes. Come on, folks. You can do it. Yeah, within the next 7 minutes.
outside in the hallway, we met with me outside in the hallway of this courthouse, where there are investigators and other people around.
Mm-hmm.
And at that time, earlier this year, did you indicate you did not wish to speak with me anymore?
No, somebody told me I ain't have to speak with you no more.
And who was it that told you that?
Mr. Hamilton.
Did you tell me that I made you uncomfortable?
No, I didn't tell you that. Because I ain't speak with you.
Say that you did.
I said I didn't speak with you, so I couldn't tell you that.
You're saying now that you did not speak with me outside in the hallway?
I'm sorry, can I have a
I'll speak up, Judge.
All right.
Are you saying to the jury that you did not speak with me in the hallway?
No, you asked me, did I speak with you? Was it other people around? I said yes. Then you said, did somebody ask you to not speak with you? I told you yes on that. Then you asked me, did I tell you? And I'm like, how am I tell you? if I didn't speak with you.
Ms. Bennett, did you express at any point that I made you want to cause yourself harm?
No, it was more not really not you, but the people in your circle, your team, or whatever they call. Because like, yeah, I was really like trying to, I don't know, manipulate, if that's the word. Yeah, I was trying to do or something.
What was it that I tried to manipulate?
Like the situation.
How did I try to manipulate the situation?
I don't know, like I felt like you kept trying to like confuse me, like you trying to do the same thing. Now you asked me, did I have a iPhone 13 in 2013 when you know an iPhone 13 wasn't out in 2013? Like they drop iPhone like every year, but I thought it was out. Then you saying made it 13, then you saying made it 12, like then you saying that somebody kicked the door, then you saying I opened the door. Like I don't know, like I don't know which one y'all working, but you working it.
Ms. Bennett, do you understand that I can't testify and that anything that goes on the record for this jury to consider, you have to say it?
Mr. Sharp? It's commentary, Christine. I'll sustain the objection.
Did you catch that? Not the objection. The judge called her Christine. A judge going first name basis on a assistant district attorney. Now, I might have misheard. No, her name is Adrienne. Let's see.
Testify and that anything that goes on the record for this jury to consider, you have to say it?
Mr. Sharp? It's commentary, Christine. I'll sustain the objection. You can just rephrase, madam.
Do you understand that only what you say is evidence and not what I say?
I don't know.
Okay. So do you understand that I have to ask you questions in order to have you answer for the jury?
I guess so.
And when you said that I was manipulating the situation, what situation is it that you're talking about?
I answered it.
Would you answer it again, please, for the record?
The one we're talking about now.
Christine is the
I need
court
you to be clear
reporter,
for the record,
apparently.
please. Which situation?
I don't know how to answer.
Ms. Van, hold on one second. I'm going to overrule your objection. Madam, you can answer the question.
I don't know how to answer what you want me to answer. Like I'm thinking that I'm answering it, but probably not good enough to understand because I don't know. When I say situation, I don't know, like, because 1 minute you on this person, then you on that person. So I don't even know which situation got nothing to do with this situation. I don't know.
All right.
You know what I'm saying? Like, you're confusing me.
All right, let's be a little simpler. Did you just tell the jury that you felt I was trying to manipulate the situation?
Yes.
And what was the situation that you were speaking of? You have to say it for the jury. What was the situation that you're speaking of that you felt I was trying to manipulate?
And that's what I'm saying. Like, I'm answering the same question.
We need 8 more likes to 200. And you have 2 minutes.
You asking me over again, like,
Ms. Bennett, do you?
I don't know, because you spoke to me like on a lot of situations. Like you was talking about Thug, then you started talking about my kid's dad, then you was telling me, asking about my mom, like, but I don't think all those things went together. Like, I don't think all of them mattered with each other. So I don't understand.
Tell the jury what I talked to you about.
I thought I just did that.
What did I tell you or what did I ask you about Thug?
You asked me, did he do a lot of things to me?
And
like, you asked me, did he break in my house? Did he get this? Did he do that? Like, all the questions you just asked. Like, I can't remember all the questions you just asked. You ask them over, I can answer them.
All right. And do you recall what your answer was?
Yes.
Okay. What was your answer?
Hey, 200 likes. I will have a sour shot. For 200 likes. See, you get rewarded for doing free stuff. like giving a thumbs up. Yay! And I agree with Welsh Lady Reads. Judge is allowing badgering of the witness. Here's the thing. Had she had an attorney, he would have cut this off long ago. Until then, cheers.
To me, when I first met you in the Wendy's parking lot.
Now you asked me, did I recall this person, and did he do these things to me? And I told you no.
What did you tell me? What else did you tell me?
Then we started talking about other situations. You was telling me about situations you had, and I think I started talking to you about my mama, which that's something I just told you. We ain't gonna do that here though.
Okay. Did you tell me that you had blocked out large gaps of time?
Yeah.
Okay. Did I tell you that an officer had stated that?
Your Honor, I'm going to object to that. I'm going to object to number one testifying and number two your testimony.
Your Honor, I'd ask that the court allow me to form a foundation for the question that will follow.
I'll sustain the question at this point in time.
Okay.
You can, if you want to lay some more foundation.
Ms. Love, you need to lay out the foundation before you ask the next question. Not giving the foundation during you articulating the question, because when you do that, it's testifying.
That's fine.
Do you recall me talking to you about Thug, DK, and Thug's brother giving you back your items?
They gave him back.
I'm asking you a question. Do you recall me talking to you about that?
I don't remember you saying that.
Do you recall me talking to you about them calling and apologizing to you?
No, I don't remember you saying that.
You don't remember that?
Mm-mm.
What else, if anything, do you recall talking to me about the first time that we met?
You know, Ms. Love, it would be really, really interesting to see if you actually had a recording of what you alleged happened during this conversation. But you already told the court and the defense you have no recording of it. And yet, you on numerous occasions wants the defense to hand over their material. You're a lying sack of shit, Miss Love. And I'm quite sure I understand why it is Miss Love.
That you're comfortable talking about to the jury?
I repeat it because I just said it, but I repeat it again. When you talk to me about the situation with Thug. You asked me and I feel like he did any of those things. And I was like, no. And I know you did ask, was I scared of him? And I'm like, no, like I don't have reason to be scared of anybody. And then you talked a little bit about yourself. And then we talked a little bit about the situation. Again, like I said, you got to keep making me repeat myself about my mom. And I said, I don't want to talk about that. And that's what we talked about.
Is it your testimony that you said that Thug did not do these things, or that you did not recall the year?
And I told you he didn't do those things.
Okay.
And you asked me, did it happen in a year? And I told you, I don't remember a lot within a year.
Can they be held for false imprisonment? No.
Did I ask you where you lived in 2013?
I think you did.
Did you tell me you couldn't remember?
No, I told you where I lived in.
That's your recollection, that you told me where you lived. Is that what you're saying?
Mm-hmm.
Basis. I sustain the objection.
Judge, you need to put a stop to this, because Ms. Love is just going around in circles, asking same things, just in a slightly different manner. But I know you won't, because you are spineless. Yeah, that's it. You're spineless.
Do you recall what the inside of your apartment looked like in Trestle Tree on May 13, 2013?
Oh,
You may answer.
I'm not sure, because I know we had remodel. So, but I think it was 2012. I'm not sure. I don't want to be wrong.
Do you recall what your address was on May 13th, 2013?
Mm-hmm.
What was it?
980 Confederate Avenue.
Was there a number or letter?
Oh, D.
Just one moment, okay? That's all I have right now, okay? Defense counsel.
Cross. Mr. Adams, go ahead, sir.
Completely useless testimony. This is what the prosecution wanted her in for. This is it. They held her in jail overnight, brought her in handcuffs and prison gear, prison garment for this. And I think it helped the defense. I hope it did it, at least. Now, cross-examination.
Ms. Bennett, good afternoon, ma'am.
Good afternoon.
I want you to do me a favor, okay?
Yes.
I'm gonna ask you some questions, and if you can't hear me, or if you don't understand the questions, I want you to go ahead and make sure you let me know, okay?
Okay.
I'll be happy to repeat myself on the chair, whatever needs to be cleared up.
Yes, sir.
Clear?
Yes, sir.
All right, I want to start first by talking about you testifying here today.
Yes, sir.
Now, you've been brought in to testify,
Yes, sir.
and you've been brought here by the state, is that correct?
Yes, sir.
All right, you didn't walk into this courtroom, you came out from, you're in custody right now.
Yes, sir.
You were placed in custody, you were in Fulton County Jail, and brought in here to testify, correct?
Yes, sir.
Now, you were arrested on yesterday,
Yeah,
correct?
yes.
And you were arrested by who, the DA's office?
No, Mr. I just remember seeing Mr. Hamilton in Clayton County.
Okay. Mr. Hamilton is a DA's office investigator, is that right?
Yes, sir.
All right. In fact, you had very many conversations with Mr. Hamilton, isn't that right?
Your Honor,
Yes.
You have an objection, madam?
not at this time.
Okay, all right.
Then
And
shut
you
the
have also
fuck
had
up.
conversations with other people in the DA's office about this case and about your testimony.
Objection, comment.
Sustained. Can you rephrase?
I'll break it down. You have had conversations with other people in the DA's office, is that true?
Objection, vague.
Yes.
As to others.
I sustained it as to the question, as to vague.
Sure.
Just rephrase, sir.
Sure, absolutely. You have had conversations with Ms. Adrian Love from the DA's office, is that true?
Yes, her and the other people too.
Right. You remember an investigator Long?
Yes.
Okay, so you've spoken over the course of the last few months with Adrian Love, correct?
Yes.
You've spoken over the last number of months with an investigator Long, correct?
Yes.
You have spoken over the last number of months with an investigator Hamilton, true?
Yes.
Okay, now, you have had an opportunity to discuss with them the things that you were asked about from 2013, is that correct?
Yes.
Now, the first person, and I want to talk to you about how we go from your conversation with them to your testimony here today, okay? Can I do that?
Yes.
Objection,
Okay.
Your Honor, as to commentary, and we would ask that we.
I'm gonna overrule the objection because he's pointing the witnesses to what he wants to talk about, so I'll overrule at this point.
Ooh.
All right.
You understood from your first meeting with investigator Long of the DA's office that they wanted you to come in and testify here in this case, isn't that true?
Well, they was telling me that I didn't have to because he presented me with some paper that I didn't recall or I didn't know nothing about.
Okay. And you told that investigator that either you didn't recall or you didn't know anything about it, isn't that true?
Objection.
Yes, sir.
As to vague.
I sustain the question, sir. Can you rephrase it?
Okay. Let me ask you this. Did there ever come a point where you were told by investigator Hamilton of the DA's office that you did not and you should not talk to anyone but him?
Yes.
Holy fuck. That is witness tampering. That is a crime. That is the unethical pieces of garbage that is the Fulton County District Attorney's Office. Holy fuck. Holy. What this representative of the district attorney's office told this witness was to not speak to the defense. That is witness tampering. Clear witness tampering. Jesus fucking Christ.
When did that happen?
I was here. It was like this month. I was here. I showed up. It was the same day I talked to Miss Long, and after the situation, they took me to him. And he told me I ain't need to talk to nobody else but him. Like nobody. Period.
Mr. Adams, I hate to break you up at this one time. I've had a bathroom request. So can we just take 5 minutes? Okay, all right. All right, ladies and gentlemen, we're going to go ahead and be in recess about 5 minutes. Please go ahead and take your respite, and then we'll come right back. All right, for our jury?
All right, that was interesting and on the record. This is completely unethical.
All right, ladies and gentlemen, our jury has left us. Okay, Lieutenant, you may be seated. The rest of you need to take a comfort break and do so at this point in time. Please make it as soon as possible. All right.
I hope the judge is going to have a discussion with this witness about exactly, because now the judge is aware of an actual crime. He is obligated to interrogate what was going on, because if this is witness tampering and he finds it, that is at least contempt of court. Yasmin Hall, this witness totally backfired for the prosecution. Yeah. What are your thoughts on today so far? Now I'm suddenly happy they did this to her. No, I'm not happy. Misunderstand me correctly here. But now this is also why the prosecution, I assume that the defense would have called her in their case in chief. So this is the prosecution preemptive the strike by doing all of this shady stuff to her. Prior convictions, prior crimes, to make her seem untrustworthy. So when she says, this investigator said this, they might not believe her, but the judge has to inquire what was said, because he just witnessed a witness alleging that the prosecution's representative did a crime. Now we can speed ahead a bit, go up to live. Oh, they are still on break. Let's make myself harder. Why does he have to break up this amazing cross? I don't know. Somebody asked for a bathroom break. I think it's one of the jurors. Oh, Welsh lady said he showed her documents she hadn't seen attributed to her too. Okay. Interesting. Yeah, I won't speculatively if it was one of the prosecutors trying to get a bathroom break. No, piss your pants. Jesus Christ. Yeah, this was crazy timing. Yeah. No, I agree with Ghostry. Witness won't know that it was witness tampering. She's just saying what was said. But the defense knows what it is. It's witness tampering. It's clear as night and day. Yeah, I'm almost speechless. Almost. Yeah. Yeah, I don't know how long this will take. Do you want to hear? Because about 23 minutes ago, my other channel just had I posted a video on it. It is the story of the Viking goddess of Easter. So let's play a bit of that, shall we? Do you see it? Yeah. While we wait for it. Well, while we wait for court to come back. And go subscribe if you want to. The wind howls, carrying with it the faint scent of blooming flowers and the promise of warmth to come. A lone figure, cloaked in the deepest red, stands atop a hill, overlooking the vast snow-covered landscape that stretches out before them. Her breath forms clouds in the air as she watches the first rays of sunlight break through the horizon, heralding the end of another long, cold winter. The snow crunches beneath her boots as she begins to descend the hill, the sound muffled by the last layer of white that covers the ground, announcing that spring is here. As she draws closer to the village, she can hear the faint sound of laughter and music wafting through the air. It is Eostri's feast, the annual celebration of the goddess' return and the promise of rebirth and renewal. The village is decorated with brightly colored streamers and ribbons, adorned with symbols of spring and fertility. The scent of roasting lamb and steaming vegetables fills the air, mingling with the aroma of freshly baked bread. The figure reaches out the outskirts of the village and makes her way through the throng of revelers, nodding in greeting to those she recognizes. She is not surprised to find the high priestess, clad in flowing robes, presiding over the feast. She spots the figure from across the crowd and smiles warmly, motioning for her to join at the wooden table. As she takes a seat, the figure notices the empty chair beside them, reserved for Eostre herself. A simple... All right, that was a taste test because the court is back. So go subscribe to my secondary channel where I read stories like this and others. Currently it has just, this is video number 5. So you have 5 stories to go between. But we are here for the trial. All right, let's continue.
Everybody see?
All right, can we ask Ms. Bennett to return to the stand, please? Mr. Adams and Ms. Love, can I see you for a second?
Oh, Mr. Adams and Miss Love, may I see you for a minute?
Wes.
Uh-oh.
To the case.
Uh-oh. I assume the judge...
Can you need to hold up, Judge? Put it back in there. Right at the door, Cap. We're coming out in a minute.
Okay.
Is he going to strike the testimony? No, I don't think so. But now it comes to how much more can the defense cross-examine her about. That is interesting. Well, they are escorting Miss Bennett to the stand. And, well, when she was brought out, she was shackled again. And now they are bringing her back, be unshackled and sit on the witness stand. And again, remember I told you this was planned? Well, I think this is more evidence because Miss Love knew that her investigator said this. And that probably knew that the defense would find out. So she made sure that this witness would look as bad as possible on the stand, in shackles, in prison gear, talking about her prior convictions and everything. Yeah, it was planned. Snivel says, probably common practice in that county. Yeah, I would assume that this, the Fulton County Prosecution's Office, under the leadership of Fannie Willis, and I believe Fannie Willis is as corrupt as they come. And I say this not, I mean, here's the thing. I'm not a religious person. I really am not. But you never lie in church. And she lied in church. It's not illegal to lie in church. I don't care. You don't lie in church. Oh, Parabellum, thank you so much. Gifting 5 memberships. It went to Sarah Jones, Rob Mill, Ghostery, Denise Sells, and Sardonisms. Congratulations, you are now members and have access to all my members-only content. Yay! And that brings us over the edge for the next spin of the wheel. Hey, it's another sour shot. Yay! Dun dun dun. For you who wonder what this is, let's see if you can see it. Sour ice pear. It's really nice actually. So it's not, when it comes to this, it is not a wheel of regrets. It's the one really nice thing I have there. Dun dun dun. Dun dun dun. Sour fisk, yeah, but it is sour ice pear. Just realized, isn't this technically a sidebar count to add? Is it? Is it? Yeah, okay. We'll have it as a sidebar. That brings us to sidebar counter 114. Cheers. Oh. Back to the trial.
I never had a problem with.
I asked you and see if we could propose.
Okay. Oh,
All right, Miss Bennett.
Yes.
Can I talk with you for just a minute?
Yes.
Okay, all right. It is highly likely that your testimony is not going to be complete today. So what I like to do is to ask you and see if we could propose something else to you. Ordinarily, with a type of confinement that you're under, once you satisfy the testimony, you're released. Okay? I'd like to be able to release you now since you're going to need to come back tomorrow. But I'd like to predicate that on if the state found you another place to stay this evening with appropriate supervision, meaning it would not be somebody that is not a female or to that extent, would you be willing, would you come back tomorrow morning?
I never had a problem with coming to court, sir.
Well, here's the
Oh, not a wheel of
here's the
doom.
challenge, and I'm not going to argue with you about anything. That was the reason why I had to sign the warrant. Okay, it's because it was
Yeah, judge had to sign the warrant.
postured to the court in an affidavit that you were not going to come. And I'm not getting into any of that reason. I'm not debating that. All I'm trying to do is to just to in the interest of fairness, because I don't want to jail you. I don't know. No court likes to jail any witness. Okay, but it's a tool that we have to ensure compliance with folks that are less than they don't want to come. That's it. So what I'm trying to do is, if you're willing to do that alternate arrangement where I'd sign an order to release you, I'll release you to the state, and the state will bring you back tomorrow morning. Okay, that's the deal. If you tell me, Judge, I'm okay with that, then I will sign the order to that effect. If you're not saying, well, if you release me, you can, blank, 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 then I'm going to leave you where you are.
No, if you release me, sir, I don't have a problem coming to court. It was a reason I didn't come to court. If you knew what was going on or what was happening with the state, you don't know why I wasn't here.
And that's not for me
I ain't finna lie to you. Like, I ain't gonna feel safe with being with them.
Well, you're going to be put up in probably a hotel is more than likely what will probably happen. Okay?
Okay.
That work for you?
Anything that I need to do for you, sir, I'm right here.
Okay, so you'll agree to that as opposed to 901 Wright Street?
Yes, sir.
Okay. All right. Then what I'll do is I'll sign an order to release you, okay?
Yes, sir.
Okay. And then you'll come back tomorrow morning. I'll need you to be here for 9 a.m. tomorrow morning. We'll resume your testimony. It is highly likely that you'll finish tomorrow, okay?
Yes, sir.
All right. Okay.
Yeah. Whatever you do, Judge, don't assign this district attorney's office to handle where she stays the night. Don't, no.
Counsels, can we go ahead and just excuse her at this point in time? And we'll just tell the jury that we're recessing for the evening?
Yes, Your Honor. The court will give us an opportunity to draft up.
Yes.
I'm not entirely sure why, but I assume I hope they will send the jury home because they are going to have a hearing about this. Because you don't break up the defense cross-examination this way unless you have a damn good reason to. Yeah. And here's the thing. So far, this is what the prosecution alleged, that she wasn't willing to come to court. And as it seems, she had no issue coming to court. So the allegation here is that the prosecution arrested her yesterday because they didn't want to risk her coming to court voluntarily. They wanted her on that stand, in prison gear, in shackles. This will be interesting. This will be really interesting.
We have no objection, Judge, but if we would like to address the court about something else related to that, we have one.
Does our witness need to be here for that or for, so we can excuse her? Okay, all right. Madam, I'm going to go ahead and excuse you, and we'll work on getting the order. So you should be released this evening, okay?
Yes, sir.
And then we'll see you tomorrow morning.
Yes, sir.
Okay? All right. Okay, thank you.
That's yours. I believe.
All right, counsels, our witness has left us. Mr. Adams, anything before I go ahead and bring our jurors in?
Yes, just one moment, please.
Okay.
Actually, we can bring the jurors in and dismiss them, then we can address the issues. So we won't hold the jurors up if that's the case.
I don't want to take that long. I'd like to go home, so. Okay, all right.
Probably because Wesley Reed says the record shall reflect the witness said she has no problem coming to court. So what legal authority do they have to detain her in hotel? Because the prosecution. I think this is as far as the judge can go. Because, I mean, he can't take her word for it. He should, but he can't. And if I were her, I would really want to be there for more cross-examination.
Excuse me.
Yes, Judge.
Okay, Mr. Adams.
This probably, this actually should not really need saying, but I'd like the court to advise, remind, or make sure it's clear to the state that, of course, this is a witness that is in the process in the middle of her testimony, and that no one from the state whose care she will be in this evening, to some extent, is to have any sort of communication with her about the testimony, or talk to her about the testimony, or anything whatsoever. That's the first request. The court is amenable to that may be the only.
All right. State, do you have any issues with that? That's a standard admonition. Okay, so, all right.
All right. Second thing, actually, I think at the bench, I heard the prosecutor indicate that Ms. Bennett would be in the care of female investigator this evening in terms of making those arrangements.
I heard that as well.
Your Honor, I don't mean to interrupt Mr. Adams' pardon me.
Yes, you do.
But, Your Honor, I was just speaking with our chief investigator, and regarding,
Shut the fuck up.
Your Honor, I don't know, I don't want to jeopardize her appearance tomorrow, but he had asked me whether the court was amenable to, if she gives the court assurances that she will return, whether the court is amenable to allowing her to go to her home.
That's not what I told you to do.
I know.
Okay, and which investigator asked you to do that? Who asked you to do that? Was it Long? Come on, tell me the truth. Don't lie to me. Come on now. I'm trying to protect everybody. No, I did. That was not the deal. Okay, so anyways, okay, all right, Mr. Adams.
It's really simple. They're female investigators.
Sure.
Based on her comfort, what I think would be appropriate. I'm asking the DA to make sure she's in the custody care of a female.
Well, Your Honor,
All
I
right.
said that.
I already did. I already said, in fact, Ms. Love said she would recommend that and said so that will occur. Correct, Ms. Love?
Yes.
Okay. All right. Anything else, sir?
That's it, that settles everything.
Okay.
Thanks, Judge.
All right. Okay, let me go ahead and call for our jurors, and anything else I need to take up while I got y'all here for tomorrow? All right. So the goal is tomorrow, we'll see if we can clear Ms. Bennett. And after that, we'll resume with Detective Quinn. Okay, and then we'll see and then I'll give some guidance as to, again, next week, Monday I'll be out. You have an admin day. Tuesday, we'll start off, we'll cover the rest of the motions in limine as it relates to the Baker case that has come out and the convictions and the for Mr. Wise, as well as Mr. Weinstein, are you prepared to take up the motion you filed in regards to the presentation of evidence and your supplemental motion?
Yes, sir.
Okay, all right. Counsel, my goal is if we complete those things on Tuesday, we will not have to come on Wednesday. All right, so that's what if we don't complete those Tuesday, we'll complete them on Wednesday, and then you'll have admin days on Thursday and Friday next week. That's where we are at this point in time. All right. Oh, one other thing. Juror, as it pertains to juror 219 that we talked about before, he has scheduled his appointment. I have a notice from his doctor, which I will mark as the next court exhibit in order and seal. But his appointment is for 16 April at 1:45. So it is my intent for us to work that morning. And then we will conclude to give him enough time, probably 12:30 or thereabouts, because I believe that his doctor, consistent with the last time that we were here, is in Sandy Springs. Okay? So I'll mark that as the next court exhibit. So put that on your radar. The morning of the 16th, we will commence, and we'll probably stop around 12 or 12:30 to allow him to facilitate that doctor's appointment. Thank you, Ms. Weaver. All right, okay. Summon our jurors, please.
Okay, let's see here. Bum, bum, ba. Bum, bum, ba. Donna T, member for 9 months. My favorite Canadian, like Swedish Viking. Thanks, Nick. Thank you, Donna, for being a member for a whole 9 months. Thank you so much. And then she gifted a membership. And that went to Brittany Gibbs. Congratulations, Brittany. You now have access to all my members-only content. Hey!
Chris. I got it. All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, given that it's 5:45 and with the consultation of counsel and what I'd like to do is to recess us until tomorrow morning. If I could get you all to be here for 9 o'clock for an anticipated 9:30 start time, we will have a regular work day tomorrow, and that will conclude. And then, as I mentioned to you earlier, your administrative pause week will begin that following week, and then we will see you back on the 8th.
Yeah, they will have an administrative break next week, so no trial next week, but on Tuesday and Wednesday, there will be motions hearings. And I will cover that in some shape or form. They would have had this on Monday, Tuesday, but this judge has a funeral to attend to by a dear friend, so he chose to move it all over to Tuesday and Wednesday. Now, I understand. He is the judge, and if he believes that his dear friend's funeral is important, then he should go. Here's my issue. He's the judge in a multi-million-dollar case where he has admonished the defense for delaying this. Yeah.
Of April, but we'll cover all that again, I'm sure. Do you have any other ministerial inquiry of me at this point in time? Anyone? Okay. All right, let's go through your admonitions. Remember, don't talk about the case at all. Do not seek any third party resources or persons. Do not talk about the case when you're at home, or let this case be talked about in the presence of third parties. If any third party were to talk with you, of course, you need to let myself and Sergeant Ingram know immediately. Leave your notepads in the basket, and you are not to view anything about the news media about this case or any other blogs or other third-party sites as well. Ladies and gentlemen, the last thing I'd tell you is, as I've told you and will continue to tell you, thank you for your patience and the attention and the grace that you've given us and will continue to give us. So unless you have any other ministerial inquiry of me, I will see you tomorrow morning. Juror 219, can you remain with us just a second? Okay. All right, ladies and gentlemen, I'll see you in the morning. Okay. All rise. Okay, ladies and gentlemen, please be seated. All right. Juror 219, I have your doctor's note. What I'll do that your appointment's on the 16th. What I will do is we'll hold court that morning starting about 9. Okay. We'll recess about 12:15. Should that give you that should give you enough time to meet that 1:45?
That'll be plenty of time.
Okay, that's what we'll do.
Okay.
All right, that's sufficient?
That is.
All right, problem solved. All right, have a good evening, okay? All right, juror 219 has left us. Anything I need to take up with you all? If not, I'll see you all tomorrow morning, 9 o'clock for an anticipated 9:30 start time. Miss Love, you owe me an order, and I'll remain to sign that, okay? We're in recess. I'll see y'all in the morning.
This
If you all could turn in your listening devices, please, that'd be great. Thank you.
This is bullshit. Not a word about what just transpired on the witness stand. That is, yeah, Cancer Moon, it's BS. This should have called for something much more than just, we'll see Monday morning or tomorrow morning again. That is weird, but it will be interesting tomorrow morning. Well, I'm free tomorrow, so I will cover this because this is interesting. Now, I do have other obligations, so it might be me just streaming it, and then I will show up later on in the stream to shout and curse and everything. Because, yeah, I have a family matter to attend to, not only because it's Easter, but a family matter to attend to that has a bit of priority. But I can set up the stream, do all the things, and stuff like that. So I am going to send you off to Dave, Making Law Simple Network. He is doing something with the What the Hales story, and he's doing some look at both sides stuff. And it's going to be spicy because apparently Jeremy copyright struck one of Dave's videos. And Jeremy, I mean, there's a bunch of us using his material, none get copyright struck. But Dave did this, let's look at both sides, and Jeremy copyright struck him. And Dave, you know him. I hope you know him. I hope you all subscribe to him or at Making Law Simple Network. If you piss him off, let's just say I don't want to piss him off, because that guy can hurt you. Yeah. But it will be interesting to see. It will start in 4 minutes, so you will be there a bit premature. But everybody, thank you for allowing me to do this, for allowing me to try to translate this, mixing the legal stuff with the snark and the cursing and the stuff. Thank you all so much. And as I always say, hug your family. Unless your family's shit, then fuck them and give your love to the people who deserve it, okay? Bye-bye.